Good morning, everybody. Happy Tuesday. Welcome to TCF Live. My name is Dan. I will guide you through the next 3 hours and 14 minutes or so of our journey through Cortlandia. We will start in St. Joseph County, Michigan. Judge Middleton.
It's alleged that at 2:26 a.m. on March 11th, you're driving a car at Maine and Michigan with a suspended license. That's a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. Carries 2 points on your driving record and requires that your license be suspended. The last time you were driving, you were on some sort of moped. This appears to be a car. You've got the driving suspended you had in 2025. You never paid the fine. I gave you a $250 fine, $125, $125 in state costs, and you never paid it. Then you had that improper load ticket. You never paid that either. So you have $410 worth of unpaid fines and costs. That's disappointing. And one time you had a chauffeur's license. You got that driving suspended in July of 25. Then you had a no ops in 21, another no ops in 21, no ops in 20, unpaid ticket in 20, no insurance. Fail to pay that ticket. That's over in Berrien, it looks like. Well, you're suspended about 4 different ways. This is about the 4th or 5th time you've been charged with either driving suspended or driving without a license. You didn't pay the ticket on the last one. So there could be jail in your future. Mr. George, is there any sort of plea offer here?
No.
What are you doing these days, Mr. Jeske?
When that happened, I was working for the hotels trying to get the mess cleaned up from the tornado that happened. It's the only reason I was even out driving at that point. I just dropped off the help I had taken out there and I was headed home.
The day was March 11th. The tornado was March 6th.
There was one heck of a disaster up there. It took almost 10 dumpsters to get that place cleaned up, just the hotels.
Yes, it was. Anyway, I'm disappointed you didn't pay that last fine. Because there's a likelihood of jail in your future, I'm going to get a lawyer to help you with this. Have you done anything to clear up your license?
I've finally got the total cost of what it's going to take to get it back. Unfortunately, it's probably going to take me a few months before I can get everything straightened out.
Well, I can wipe out some of the fines with a jail sentence, but
Unfortunately, I'd end up losing my house, I think.
yeah, then you need to, first thing you need to do is pay your fine from 2025. I put you on a payment plan, then we tried again in January. You didn't make any payment. The payment plan where there's no payment isn't a very good plan. So I'll show a plea of not guilty. Appoint an attorney. Set attorney pretrial for May 1. I gave you just a fine, time to pay it. Even though that was about the 4th or 5th offense, this is the 5th or 6th. So I don't know what you were doing at 2:30 in the morning, but we'll find out. Your story's plausible, but you can't drive. And I suspect you've been trying to stay under the radar. All right, need payment plan. As I said, I can wipe out some of those old fines with jail. So I'm sure you'd rather pay them than go to jail, but you also got unpaid fines in other jurisdictions, but I'm not worried about them, just us. All right, you can go with court officer. I'll see you on May 1st at 8:30. Elizabeth Boyd.
Barbara, thank you for the $10. I'm glad you enjoyed that slideshow yesterday. I had a lot of fun putting it together, so hopefully we can do stuff like that again in the near future. And Great Granny, Dan is one of the better human beings in this world. He shows us each and every day how much he cares for all of us. Thanks, Dan, for being you. I know Beth has a lot to do with you being nice to us. Great Granny, thank you. That's very kind of you. I just try to be worthy of all of you. Look, you have a lot of places to spend your time, and it is never lost on me that you choose to spend it with me. So thank you so much.
You showed up for your arraignment in October of 23 and you wanted to get a license. So I adjourned it till December of 23 and you didn't show up. So I did a show cause and set it again for December 19th and you didn't show up. Then you got arrested on the bench warrant on March 23rd. You came into the counter and posted the bond. I recalled the warrant, and that may have been Judge Pattison. And set the matter for today. So let's take a look at your current driving record. The original ticket was 4th and State Street in Three Rivers at about 11:30 at night on September 9th of 2023. You didn't have your taillights on. So let's take a look. I bet they didn't run a new driving record. Jenny or Shana, could you run a new driving record for Elizabeth Boyd? We'll see what her status of her license is.
I have my permit and I have my driving test today, actually, right after court. So.
All right. Well, that's good. It only took you 3 years to do it, but sounds like you're on the verge of getting your valid license. Mr. George, what if we just adjourn this to see if she actually gets over the hump?
That's fine with me, Your Honor.
All right. Where did you go for 3 years? 2.5
I
years?
moved to Niles. Yeah, and I forgot about court and stuff, and I didn't get the mail, so that's completely my fault.
All right, where are you going to do your driving test?
On Three Rivers.
Well, let's reset that for 1 week. April 7th. Will you be here then, Mr. George? To allow defendant to pass driver test. If this hits your record, you won't be able to get your license for at least 180 days. If you pass the test, for what it's worth, I do have $400 worth of bond in here, Mr. George, so there's more than enough money to pay any fines and costs. If you pass the test, Mr. George could give you some consideration and allow a charge that would let you keep your driving, get your driver's license. Now, last address we had was Clear Lake Road. Is that still valid?
Yes.
All right, I want you to ace your driver test and come in here next Tuesday.
Yes, sir.
Bring license. I don't think you have any unpaid tickets. Run new driving record. All right, let's see if you can get a license. Mr. George could help you by reducing the charge, which would allow you to keep your license, which is really what we're looking for in the first place.
Thank you.
All right, good luck on your driver test. Abby Pitcher. I'm not shocked at this, but our friend September Knowles has failed to appear this morning. That poor girl is a cork floating in a very big ocean. Good morning. Are you Abby Nicole Pitcher?
I am.
You from Gwynn?
No, I just moved back down here after I turned 18, so I haven't been able to change
So
the
you live at
address.
Cory Lake Road.
Yes.
All right, that's a lot closer than Gwynn. All right, you got a ticket in Three Rivers
Yep.
for driving without a valid license and no license plates. Let's take a look at your ticket. There used to be an Air Force base in Gwynn, long time ago. Part of Anatomy of a Murder was set in Gwynn. But you don't even know what I'm talking about, but it's about a 60, 70-year-old movie. Anyway, you got a ticket for speeding. No license ever applied, an improper plate. The 62 and a 25. Yee. 4th and Pleasant Street. That's not a good place to go 62 miles an hour. They cited you for 30. That speeding ticket looks like it may have been defaulted. Anyway, no license ever applied is a misdemeanor punishable by up to 90 days in jail and a fine of up to $500. The other charge, improper plate, is 90 days and or $100. Yeah, you just don't have a license. Used to be blonde.
Yeah.
You had a real ID, which is why they've got your picture. Mr. George, would you dismiss the plate charge? All right. The principal charge is driving without a license ever acquired. Prosecutor would agree to dismiss that charge, which would save you $100 if you plead to driving without ever having a license. What about the speeding ticket?
based on the speed that she was going, leave that default. You're sure you got.
I guess it's not a default. The fine for the speeding would be $90. Anyway, that's the charge. The city attorney would dismiss the no plate charge. The charge of speeding 30 and a 25 would stand. And that would cost $90. And if you plead to not having a valid license ever, you would get a $200 fine. So are you willing to plead to that charge if the prosecutor dismisses the charge of no plate and admit to the speeding charge? Or do you wish to plead not guilty?
I'm not guilty.
All right. I'll set it for a not guilty plea. Are you doing anything to get your license?
Yes.
Tell me about that.
All I have to do is go up and take the test. I did the driver's training class. I took the test. I just gotta do the drive, which I was able to since I did just move from Marquette down here, so I have to do it here. So I had one scheduled in Marquette in Gwen, but I had to get out of there.
All right. I'm really curious to know how you ended up going 62 miles an hour on 4th Street, but
I'm sorry, but
don't say any more about it. Not at this, not yet. Tell me about, why do you have to take a drug screen? You said you passed the drug screen.
no, the driver's training.
Oh, you said
class.
driver's training, and I guess I heard drug screen. So, do you have a time to take the test?
Not yet. I gotta call up still because last time they were still packed and full. So they said give it a month and call back.
Well, we'll give it a month. We'll set it for May 5th. Now, right now, you don't have any baggage on your driving record. There's nothing. You just don't have a license. If you get this, you won't be able to get a license for 180 days. So you need to wake up from slumberland, and between now and May 5th, take your driver test. And if you come in here and show Mr. George that you've got a license, he may give you some additional consideration regarding this. Okay.
Okay.
What do you do now that you're back here in Three Rivers?
Still working on that. Right now I'm working to get an apartment. Yeah.
All right. Now, if you move, we need to get your change of address. Who lives on Corey Lake Road?
My boyfriend, his mom, and 2 brothers.
Okay. The other thing is the Secretary of State believes you live in Gwen because that's the address on your ID. And any mail they send from the Secretary of State goes to the address on your license. So when you go in to take the driver test, make sure you get a new address.
I will.
And they don't forward Secretary of State mail. So if it gets sent to the address on your license, it'll just languish there. All right, we're gonna see how you can do in a month.
All right, good morning once again, everybody. TCF Live on a Tuesday. Programming note, we're going 3 hours today, not 4. Bear that in mind. Little bit of a slower start out in Cortlandia, but there are some other courtrooms that look like they're getting ready to get going. In the meantime, we'll continue to ride with Judge Middleton for a while.
In the meantime, Mr. George, I'll give you a chance to get the report on this and see what the deal was. Bring proof of license or permit. Because you need to do this anyway. You need to get off the driving suspended merry-go-round and get an actual license. Right now, there isn't anything prohibiting you from having a license. Now, whoever's car you were driving, they could be in trouble for allowing an unlicensed driver to drive their car. So don't drive a car and get your license, and maybe we can fix this on May 5th. All right, you're good to go.
Thank you. Have a good day.
All right, we're working on it. Thank you. We're working through this. We got one pretrial that Abby has brought us, and we have Mr. Savon Jones. This is file number 252435 ST. You're Savon Ramon Jones.
Yes, sir.
You got a ticket for driving suspended at 131 and M60. The cops spent a lot of time there. Doesn't say anything about why they stopped you. It was at 6:53 at night on November 20th. Nothing really untoward about that. You didn't show up at your arraignment in December, and we issued a bench warrant, and you got picked up on the bench warrant, posted a $500 bond. I think you did an arraignment. You didn't show up for the arraignment. I believe I did a show cause, or Judge Pattison did. Then you were set for March 16th, March 10th. The power went out and the courthouse was closed. It was a mess. So anyway, we gave you a new notice and you're here today. So let's look at this. This happened November 20th. I don't know why you're suspended. Let's take a look at that. Your license is expired. It's also suspended. You got unpaid tickets from back when they used to suspend your license for unpaid tickets. Ugh. Starting in 2016, you got a driving without a license. You failed to appear in court, and they issued a FAC citation. That stands for fail to appear in court. And then you didn't pay it, so they did a FCJ suspension, which is failed to comply with judgment. So that started your trip on the merry-go-round. 2019, you got another ticket for no cycle endorsement. And it doesn't look like you paid that. You didn't. Then failed to appear in court. Boy, I'm glad you're here now. You got a bunch of failed to appears or failed to pay in Kalamazoo, which is part of why your license is suspended. It's also expired. Mr. George, any input on this one?
Your Honor, I don't have anything this morning.
Oh, it's not yours. It's in Fabius Township.
Well, I don't think it's under state.
Oh, okay.
It's under state statute. Anyway, I'm not gonna put you in jail for this. I've got $500 of bond to pay a fine. But if you plead to this, it's gonna go on your license as a driving suspended charge. It's gonna make it all the more difficult for you to get your license back.
Well, Your Honor, I got my license now. I just got them in the mail
Do
yesterday.
you have your license now?
Yes, sir.
All right. Hold on to that. We'll see if we can get, Josh, with that, would you do anything with it?
What are the charges?
A driving suspended, and he now has a valid license.
There's no civil infractions or anything?
257, 326, but there's there's nothing else attached to it.
No, yeah, that's fine. I'd do an allowing another.
All right, Mr. Robert is feeling generous at the end of his career, but he, like the rest of us, likes to try to help people get off the driving suspended merry-go-round. You've been on it because you had a bunch of unpaid tickets. I'm very pleased to see that you have a real live driver's license. This is a legit. Some of the Mexican ones, I can't always tell.
Well, I made a lot of mistakes younger, so it's time to grow up. So I had to do what I had to do.
I can't get this one to come up. Laura? Would you have brought a new driving record on that one? Or have a seat for a sec. If it comes back as legit, the prosecutor would reduce the charge to allowing another to violate the motor vehicle code. That one carries no points, doesn't get abstracted to your license, and wouldn't affect your ability to keep or maintain your license. I have more than enough money to pay your St. Joe County fine and give you the balance. So have a seat for a minute. We'll confirm that you've got a valid license. And
That allowing another charge that they use in Michigan all the time is the weirdest thing in the world. I get why they do it, but it's a misapplication of the law and a dumb law at that. To say you're allowing another and the other that you're allowing is yourself, that's just circular logic in my opinion. Anywho, let's move on. Let's go to Lake County, Ohio. We'll say good morning to Judge F. Word.
Alternative to Signature Health to do a treatment program, an outpatient treatment program that still allows me to be with my psychiatrist and my anger management that I'm starting to do again.
Hold on, what kind of program?
It's called MAPS. MAT.
What is it?
It's to help me get over the urges and the craves of wanting to use.
How?
I don't know how. I don't know the full thing about it yet.
How did you find this program?
Actually, my friend found it for me, Miss Alicia, and then they came in and talked to me about it yesterday.
Who's she?
What?
Who's Alicia? And what's her, how did she find it?
She called Signature Health for me because through Signature Health, I have my anger management and my psychiatry. So I thought that they could find me a program that would help me get the tools that I need other than going away for
tools for what?
The urges and craves of wanting to do drugs.
Of what kind of drugs?
Any drug that I want to do, meth, pills, whatever I want.
Right.
So the reason I did this is so that I can also be a father to my daughter rather than go away for another 5 months. I could help provide for my family and my daughter and still work and be on the outs.
Okay. Well, sometimes you sound like a robot. You've told me that before, right?
No.
Yeah, you have. But anyway, so when the MAP program, do you know what that stands for?
No, I do not. Sir.
Medically assisted treatment.
Okay.
So what kind of meds?
I don't know what they're gonna offer me. I haven't been assessed yet. That's tomorrow, apparently,
Well,
April 1st.
okay, I know what what's the purpose of the medication?
To take away the craves,
The
to
craves,
help my addiction,
the craves for what?
being an
specifically?
addict.
Okay, well, there's nothing that takes away the craving for meth. Are you aware of that?
Oh, I'm not, sir,
Okay,
because I really don't do meth. I told you that the last time. She would have never let me out of her office. They have the
all
same.
right, listen,
All right.
you are where you are, okay?
Okay.
So, well, you don't seem like you're very receptive this morning.
I'm very receptive, sir.
Okay.
I'm just trying to take this all in. I came up with an alternative. I guess it's not good enough, so.
Well, I didn't say it was good enough or not good enough. I'm asking you questions to try to find out where you're at, okay, in your situation, and where you want to go to get out of your situation. So don't give me any shit, okay, because you don't like the questions, or you don't like what I'm saying, or you're anticipating what I'm going to do, because you have no idea.
I have no idea what you're gonna
Okay.
do, sir.
So if you are placed on medically assisted treatment, that's to take away the desire to do opiates. You have a problem with opiates?
Apparently, yes.
Well, I'm not asking what's apparent or what's not apparent. I'm asking you if you do or you don't.
Yes,
Okay. Here, I'm gonna come back, okay? 'Cause
I said yes.
Because he's got a really shitty attitude to start off, okay? So I'm gonna come back and you can talk to him or not talk to him, but I'll be back in 5 minutes.
Well, alrighty then. So we'll rotate back to Judge O'Donnell after 5 minutes or so and see how that plays out. But let's go back to Michigan. Judge McNally's got a pretty full courtroom this morning.
Arrived at the scene, the defendant was already gone, but they did have ring doorbell footage from a neighbor. According to the police report, it states Solomon Knight was with his shirt off, yelling and pounding on the door, trying to be let into the home. Knight was screaming and calling the victim a bitch in the footage. Knight can additionally be seen picking a chair off Brown's porch before leaving the area.
That would happen? Yes, sir. That's a little different than knocking on the door, isn't it?
I mean, I necessarily wasn't thinking that I was pounding.
I'll just ask you, is that what happened? Is that what happened or is that not what happened?
Yes, that's what happened.
Read that again.
Solomon Knighton with his shirt off was yelling and pounding at the door, trying to be let into the home. Knighton was screaming and calling the victim a bitch in the footage. Knighton can additionally be seen picking a chair off Brown's porch before leaving the area.
Is that what happened?
Yes, sir.
It's a little different than knocking on the door, isn't it?
Yes.
Guilty plea is accepted, failure to refrain from having contact. Why is he doing this?
Judge, is the,
I mean, it's two wrongs don't make a right, okay? He doesn't get to come in here and defend his actions and then say, well, she went over there and she committed a malicious destruction of property. Nobody heard me say I'm condoning her conduct, but I'm certainly not, if that happened, I'm certainly not condoning his though. So what do you want to say?
so Your Honor, it's really about these kids. And these cases are very tough when the two individuals have children together. And they live in very close proximity. They live in an apartment complex on either side of each other. Mr. Knighton's mother is here. She's just gonna move him at this point because this is not, they're gonna continue to be in this court. Mr. Solomon is trying to move forward. He's in school. He's supposed to be in school right now. He's going to Universal Technical Institute in Canton. He's helping raise his children. His mom gets the children. He'll keep the children. He's trying to get a job. He lost his other job at GM because of all of this,
How'd you lose the job?
because he got charged with assault or domestic violence.
She got admitted to a mental hospital, so I had to get the kids. And I was still on my 90-day probation. And then my last security job, she called up there and claimed that I beat on there and
So it was a security job. I misspoke. It was a security job that he lost because of this situation. At this point, he needs to move. So I would ask that the court maybe order more days on the work program or another anger management class. If he goes to jail, it was supposed to graduate in June of this year.
Did he do the 8-week thing?
Everything's completed, yeah.
Did everything.
Everything's completed. And he's set to be discharged coming up in June 18th. Everything is done, other than this original contract where he's been compliant. And I did talk to the victim as well. She did not want to be here for this day. She did not want to speak or say anything. Yes, our legal friend is application for a case with him as the victim as well. I agree again with House Counsel here that this is going to continue to be a problem with them just being in the same area as each other and having a child together.
No, you've had a history of domestic violence, so you had one taken under HIDA in 23, that's fine, but then you had another one dismissed, and then this conviction, and then you're violating the orders, you had another one dismissed in 94. It seems like there have been multiple charges. I'm not going to assume you did anything wrong because they dismissed the cases, but the bottom line is that you're violating orders here. And you're going to get yourself in some deep trouble. And I mean, that's a little bit more than indirect contact. You tried to play this down, right? Said you knocked on the door. You did more than knock on the door. Shirt off, yelling the B word. Pounding on the door. What do you think?
Honestly, Your Honor, I'm not sure at this point. Again, I think they're going to continue to be an issue back and forth. They don't contact orders.
Well, I'm not going to put up with this, okay? You're not going to violate orders. As far as I know, there's no judge that ordered her not to have that gentleman there, correct? Correct?
yes.
Okay. Then who are you to play judge and jury out there?
Just my kids.
Well,
Was just to respect on my kids. That's all.
when's he scheduled to come on?
June 18th of 2026, Your Honor.
Judge, the graduation is in 2026. He's supposed to graduate.
Graduate.
Yeah, he's at Universal Technical Institute in Canton.
You pay additional costs of 70. I'm extending probation by a month until July 18th. You're to pay additional probation fees of 20. You're to serve 2 days on the court work program and pay $70 for that. So your total here is 165 plus 2 days on the court work program. I'm going to caution you. Do not have any more contact with her. Do we understand?
Yes.
I think the initial order says that he can have contact to effectuate visitation, does it not?
Yes, Your Honor. Between his mother, effectuates the visitation.
Okay. Defendant. Can't read my own writing. Isn't that horrible? It says mother. Somewhere in there it says mother. What did I say?
So on our no contact order, I said, state that he's not to have contact with the victim except to exchange minor child. That's how it's worded for us.
Oh, defendant permitted to have indirect contact through his mother to effectuate visitation with the minor children. Is that not what I told you?
This was originally Ms. Tessino's case, but I'm just taking it over from here. I can go ahead and update it, but it's hard to read on the order.
Defendant permitted to have indirect contact through his mother to effectuate visitation with minor children. Is that not how we were playing it before, Mr. Knighton?
Yes, we were.
Okay, well, that, I'm still gonna allow that, but no more of this. Can you pay the 165 now, or do you need time?
Um,
How much time? All right, you pay this by April the 8th. Okay? If you need more time, we'll go on Zoom. I'll give you an extension. Best of luck. Thank you.
Thank you, Judge.
Do I have Gage Maximus Cartier here? Gage Maximus Cartier here. This was actually set for 10:30. Is this set for 10:30?
Yeah.
Yeah, so it's fine. I'm gonna pass that. Sikan. Jaspreet Singh Sikan.
He's on Zoom, Judge. He's coming in right now.
This is 26W841410. Mr. Sikan, you have to start your video and tell me your name, please. Your name?
Yes, sir. My name is Jaspreet Singh Sikan.
Where are you at? You're not in a car, are you?
Yes, sir. I'm in a truck.
You're not driving, are you?
No, I'm not driving. I'm in a sleeper berth.
How much more you would need time to pay? You were supposed to come in with the money by the 16th. Next time you have to do this on or before the due date. Mr. Martin, I'm going to ask you not to smoke, please, sir. Mr. Sikan, how much time do you need?
Sir, actually, I am totally broke. Can you give me some relief if it is possible?
I mean, I'll give you more time to pay. How much time do you need? I can't do any better than this, really, sir.
Okay. Okay. Can you give me 1 month more?
I'll give you till April 30th. Okay? April 30th you pay by. Good luck to you. Thank you.
Thank you.
Is Pantal here? Brandon Ross Pantal? 24B147651. Your name?
Brandon Ross Pantal.
All right. All right, I accepted your pleas to probation violations back on March the 3rd. I revoked your status, entered a conviction. And I believe you were represented by a lawyer that day, were you not?
Yes, Mr. Haynes.
Well, let's get Mr. Haynes in here. Did you talk to Mr. Haynes about this morning yet?
I asked him, he said you would, he told me to wait to talk to you first and then talk to you.
All right, so I'm gonna revoke your status, enter the conviction, and then I'm gonna sentence you. So why don't you go talk to Mr. Haynes first, and then when you guys are done, when he's ready, I will call your case, okay? You're up to call it. Dion Tawadhi Law, 25F243345A and B and C. And then 25B148445A. Your name, sir?
Yeah.
All right, so you will, you're here for a show cause on 345A. Yo 225. 345B, Yo 213. On 345C, you owe 327, it looks like, or is that down to 127?
127 is the balance on that one.
127, and then you owe 340 on, you're driving on a suspended that was reduced to no ops. You have the right to a lawyer. If you plead guilty on the civil infractions, you could get 1 day for every $10 owed. So you get 23 days on file A, You could get 22 days on file B. You all right? I know it's hot in here.
No, I'm okay, I'm for the night.
If you want to sit down, you can sit down. I don't want you to faint there. Go sit down at the table behind you.
Okay.
You sure?
Yeah, but
And on file C, you could get 13 days. And then on the misdemeanor, you could get 90 if I find you could have paid and failed to pay, and your failure to pay was not without your fault. So do you understand all of that?
yes, sir.
All right. I'm gonna cut this short. You look like you're gonna faint.
Okay.
Why don't you sit down? I'm gonna feel a lot better if you sit down behind you. You have the right to a lawyer. I'll be happy to provide you with one at public expense. You have the right to a hearing. At a hearing, you can question their witnesses, bring in your own, use the subpoena powers of the court to bring in those witnesses. You can testify or remain silent. If you remain silent, that silence would not be held against you. You understand all that?
Yes, sir.
If you plead guilty, you're giving up your right to a contested hearing of any kind. You understand that?
Yes, sir.
And you understand I said you have the right to an attorney. Would you like an attorney?
Yes, sir.
You work?
Yes, sir.
Where at?
Henry Ford, I just,
Nice and loud. I can't hear you. Henry Ford, what?
Henry Ford Hospital.
What do you do there?
For about,
You haven't been taking care of these at all, Mr. Law.
I was unemployed for a very long time, but I just got employed.
I mean, I'd like to give you another payment plan, but you've been playing around with this for a long time now. This has been going on for a year. Well, I know, but it has multiple times, and I keep telling you, giving you more time. I'm gonna give you a lawyer, and we'll go from there. You gotta stop ignoring the courts. Bad habit, really bad habit to get in. I'll go ahead and give you a lawyer, and you'll meet with the lawyer, and then you'll come back in here, okay?
Yes.
Thank you.
That's, you know, all of it.
People against, Julian William Tom. 260-647-873.
He's on Zoom, Judge.
Did he meet with the department rep for Trenton?
He did.
All right, come on in here, sir. Your name, please?
Julian William Tom.
All right, so you met with the department rep and you are going to plead responsible to the charge of impeding, true?
Yes, Your Honor.
To that charge, responsible or not responsible?
Responsible.
All right, I'm gonna accept your plea. Your total's $155. You can pay that today, correct?
Yes, Your Honor.
You can go right on 33court.com with your case number and make your payment. You're all set. Best of luck.
Okay, we'll come back to Judge McNally, but let's go back to Judge O'Donnell. He's back in court with that defendant.
Savon, anything you want to say?
Your Honor, with regard to the incident matter, I know we briefly, in that break, John and I went over more thoroughly what the MAP program was. He understands what that entails now, fully. With that regard, someone from Signature Health, a licensed social worker, Brianna Wiley, visited him at the jail, informed him what the MAP program is. If you'd like to participate that, Your Honor. He has an intake appointment that's scheduled for April 1st at 2 p.m. at the Willoughby location of Signature Health. He's already acclimated there by getting med compliance and seeing a counselor and his psychiatrist, as well as anger management. Your Honor, during this period of time that he was not reporting to probation, a lot was going on in his life. He lost his best friend. He was a pallbearer for them.
I heard that last week. I know that. But then again, he didn't turn himself in either.
Correct.
They had to go grab him at Riders Inn, so.
Correct.
So that only goes so far, that stuff.
Right, Your Honor. Just trying to detail it for the record so that it's aware and the court's aware as well, just to reiterate what we went over last week.
Okay.
Additionally, his girlfriend did have an issue with emergency surgery that she had to be rushed to the Cleveland Clinic for. He, on the other hand, was also helping his mother out. She broke her hip and he was caring for her as well. And that he does have 2 sponsors that he was maintaining. He reconnected with his daughter, wants to continue that connection that he does have with her. With that, Your Honor.
He's done that in the past, right? Well, you weren't here. Mike Murray was representing him. So I'm aware of what he's done in the past and how he's had periods of good and followed by periods of bad. And so I'm pretty well aware of, since we've been seeing each other for 4 years now, right? So, but go ahead, I didn't want to interrupt you.
He has been working the Riders Inn, which you may have already previously known that as well. And he does have an opportunity with his concrete to be in the union. So he does want to take full advantage of that opportunity as well, but he understands at this point in time, after our long conversations, that he needs to help himself before he can continue on the path of either helping others or kind of progressing into his law-abiding life with that respect. But he does need...
I mean, everybody wants him to take advantage of these opportunities. Go ahead.
With that, Your Honor, we're just asking you for consideration for the MAP program. We understand that he did participate in some sort of IOP in the past. We believe potentially with the difference of having a medically assisted treatment opportunity as well as participating in what he has done before, that it could be helpful for his instant matter.
Anything else you want to tell me?
I want to apologize from earlier. I didn't understand fully what was going on with the whole program. She came yesterday and just made me sign some papers and didn't fully explain everything, so I want to apologize to you, sir. That was my fault.
How long you been going to Signature?
Since 2021, I believe, on and off.
And who have you, what kind of services have you been?
I've done grief counseling, anger management in the Painesville one. I just signed up for anger management at the Willoughby one. I have my psychiatrist at the Willoughby one. Mary Winfield is my doctor.
Did that psychiatrist ever prescribe you medication?
She has, for sleeping.
All right. When's the last time?
I talked to her a month ago.
Okay. How long has he been in jail on this one?
He has 14 days of credit on the violation.
Isn't he due off pretty soon?
In May, Your Honor, May 25th.
Besides, I assume you're going to see this psychiatrist again at Signature?
Yes, sir.
What other doctors do you go to?
Just Mary Winfield. She is at the Painesville location, Signature Health.
What does she do?
She's my regular doctor.
Primary care doctor.
Primary care. I couldn't think of that word.
There you go.
All right, I'm going to extend your community control to May 25 of 27. You're gonna serve 14 days in jail with credit for 14. No illicit drugs or alcohol. The screens. You're fully engaged with Signature Health, which means going there tomorrow, doing the evaluation, following all their recommendations. You're going to do the decision points program, follow those recommendations. The only doctors you can go to right now are the signature doctors. You're to go to only one dentist and one pharmacy for medication. Take your medication as is prescribed, sign releases for probation so they can get all your records to wherever you go. Maintain full employment, pay the costs and supervision fees. Now, the last time that when you hurt your ribs, you went to what, urgent care or an ER? Which one?
ER.
Okay. You are obligated to inform probation of anywhere else you go. You're not to go anywhere else for doctor care unless it's a vital emergency. Because we don't want you going around to this place and getting a script and this place and getting a script. You understand that?
Yes, sir.
Okay. You are your own worst enemy.
I am.
Ms. Randazzo, any other terms?
Nothing further, Your Honor.
Okay. You have a tendency to do poorly, then to do well for a period of time, and do poorly. So I don't know what the answer is, but you have the answer. So you're either gonna solve the riddle or not solve the riddle. That's up to you. Any questions?
No, sir.
Okay, that's it. You gotta go to probation as soon as you get out of jail today. You understand that?
Yes, I do.
All right.
Thank you, sir.
Okie dokie, friends. Let's go to Florida. Wade Mercer. See what's going on there.
Mr. Morris, good morning. Mr. Morris, you're here because you've been accused of one count of grand theft. Mr. Morris, you also appear to be on probation in two different case numbers. So, Mr. Morris, I'm going to tell you there is probable cause in the complaint. I've also looked at your criminal history and the probation files. And I think you're entitled to a bond in the new charge, but not necessarily a bond in a potential VOP. I'm going to listen to the attorneys before I make that bond decision. Mr. McDaniel, anything?
No, nothing, Your Honor.
Mr. Mitchell?
What are the two VOP cases?
Jackson County 24-289 CF and Washington County 24-2 209. Looks like a 5 or 0, my handwriting.
Okay. We just request a 7-day hold be put out so we can contact probation and see if they're going to put a warrant out.
Thank you. So, Mr. Morris, what I'm going to do is set your bond at $10,000 cash or surety on the new charge with a condition of no contact with the alleged victim. Don't try to post the bond because I'm going to hold you for 7 days. I'm asking Mr. Mitchell's office to notify probation office of the arrest, and they have 7 days to seek a warrant from the circuit judge if they're going to do that, or circuit judges, because you're on probation in 2 counties, it appears. So I'll see you in 7 days and we'll see if they have a warrant or not. If they don't have a warrant, I'll release the hold and you can post a bond if you wish and be released. If they do have a warrant, we have to see if that warrant has a bond on it. Mr. Morris, do you have any questions, sir?
No, sir. Thank you.
Yes, sir. We'll see you in 7 days. We have Bernard Williams next. Mr. Williams, good morning. Mr. Williams, we got a report back from the evaluation I think you participated in yesterday. So, Mr. Williams, let me see what the party's positions are, and we'll go from there. Mr. Mitchell? Let me start with Mr. McDaniel, because I think he's the one making the request, I believe.
Your Honor, yes, we did complete that mental health evaluation yesterday, Your Honor, and the recommendation from the mental health professionals was that he be sent up to the Baker facility and
We just asked that, you know, he go ahead and be sent up to the Baker facility. So your request is ROR and then give him a court date? Yes, Your Honor. And Mr. Mitchell, what's your position?
Yes, as long as there is a Baker Act hold in place, we are okay with an ROR if he will be released to that facility.
So Sarge, my understanding from the email I got from Mr. McDaniel yesterday is that they have signed a Baker Act that they would like for him to get further treatment and evaluation. Is that right, Sarge?
That's correct.
So, Mr. Williams, what I'm going to do is we want to get your mental health straightened out to the best of our abilities. What we're going to do is I'm going to give you a ROR. ROR stands for your release on your own recognizance. So you're going to get out of jail today, but you're going to go from the jail to a behavioral facility so they can do an evaluation and determine if there's a medication need or something that might can do to get you thinking more clearly. The allegations against you are pretty bizarre, so we got to try to get you on the right track. Mr. Williams, the jail's also going to give you a notice for your court date. What notice, Mr. Mitchell, would you like?
27th.
April 27th?
Yeah.
If we can give him a notice for April 27th at 9 a.m., Mr. Williams, that will be your court date. That notice they'll put in your hand will be the only notice you get. So, Mr. Williams, do not lose that notice. So, Mr. Williams, they're going to get you down to Panama City, or usually it's Panama City is where the closest facility is at. That'll happen sometime today. Do you have any questions, Mr. Williams?
No, no.
All right, sir. Wish you the best. Sarge, I think that's it for our short first appearances. We have one add-on case from yesterday, but as far as jail cases go, I think that's it. Anything else from the jail?
No, sir, that's everybody.
Mr. Mitchell, anything you need the jail for?
Nothing from the jail.
Mr. McDaniel? Sarge, do you have anything right after first appearances? Is anybody else using this connection?
No, sir.
Thank you. We'll just stay on this same connection for this last case. Thank you.
Uh-huh.
We have Zonim Emmanuel Scott. Mr. Scott, come on up. This is case 26-149 CT. Mr. Scott was set for arraignment yesterday. I believe Mr. Scott's or his family called the office and explained he got confused or something about the court date. There was some kind of miscommunication, so he was told to be here this morning. Mr. Scott, I'm going to appoint the public defender's office to represent you and ask that you listen to Mr. McDaniel.
Your Honor, Mr. Scott, I believe he's hired an attorney yesterday. So at least that's what he advised me. I don't know if the attorney's filed anything yet. Probably just set him on another court docket if the court's agreeable with that. He's obviously going to show up. He showed up today. He's a correctional officer. We know where he's at, so he's not going nowhere.
Mr. Scott, your charge is leaving the scene without giving the information required under Florida law. And let's see if an attorney has filed a notice of appearance or not. There has not been an attorney filed a notice of appearance. Who did you hire?
Attorney Stephen Higgins.
Stephen Higgins? And where's Mr. Higgins out of?
Higgins?
Sure.
I'll have to look for it.
Yeah, was he Tallahassee, Panama City, where?
Stephen C. Higgins from the law place. He's stationed out in, I think it's at Tampa.
It's like
You just hired him over the internet or over the phone? Over the internet?
I just called him and hired him over the phone.
Has he actually been hired?
Yes, sir.
You've actually paid him and everything?
Yes, sir.
When?
Yesterday. I have the receipt for it.
You know when you paid him? What time? Because he hasn't filed anything, which is usually when an attorney gets hired, the first thing they do is file a notice of appearance.
He had texted me this morning and he had said that we filed our notices on this civil infraction, but the criminal case is not showing in the clerk's site yet.
It's in warrant status, so it's not going to show. So they can't see it because of it being warrant status. Under Florida law, it's restricted until the warrant is served or set aside. There is a notice of appearance in the civil matter.
And I had paid that at 4:55 p.m.
And it was also real late in the day. Okay. So what we need to do, Mr. Mitchell, what's the state's position then as far as setting aside the warrant and giving him a court date?
I have no objection to setting aside the warrant. I think even though a notice of appearance hasn't been filed, I think we could go ahead and just set them on the April 9th date. If it doesn't.
April 9th is just 10 days away. You want it set for April or you want it set for May?
We can set it for May.
Okay, what I'm gonna do then is I'm gonna set aside the warrant issued in your case. It appears to be an honest mistake. You showed up here today. Appreciate that. So we're gonna set aside the warrant. Secondly, what we're gonna do is we're gonna give you a notice for the private attorney docket, which is May the 7th at 1:30. We're gonna get you to sign that notice. You need to make sure you get the copy of that notice to your attorney, so communicate with his office. Once that warrant is set aside, he'll be able to go in the file, or his staff will be able to go in the file and file a notice of appearance. They just can't do that while there's an active warrant. So there's your copy of your notice for your court date. We'll get you to sign it, give you a copy of it.
And I called yesterday to figure out what the date was and told me that morning.
Yeah, and your notice came back, so you did not get the notice. I don't have any reason to doubt what you're saying. How do you say your first name?
Zonum.
Zonum?
Yeah, I live in this one.
All right, Mr. Scott, we'll see you on that date, okay?
Thank you, Your Honor.
Have a good day, sir.
Appreciate it.
I gotta say, I'm a little confused that this guy hired an attorney out of Tampa if he's all the way up in the Panhandle. I hope for his sake that this whole thing is able to be handled via Zoom. If he ever has to show up, the expenses are gonna go way, way up. But that's his choice. Let's go back to Michigan and back to Judge McNally for a while.
Lawyer?
You're going to plead to impeding traffic, correct?
Yes, sir.
And that's what you want to do?
Yes.
So that charge, responsible or not responsible?
Responsible.
Okay, I'll accept your plea. 150 is your total. The speeding's dismissed. Any questions?
No.
Okay, you can go right down the end of the hall, make your payment. You're all set. Thank you. Ali Abdullah Al Hassani, 260-647-961. And I'm gonna need Alec Johnson brought in. Are you Mr. Al-Hassani? Come on up to the podium. Come on up to the podium, sir. All right, your name?
Alec Johnson.
Okay, so you are going to plead responsible to impeding traffic, true? You've got two other entries on here to that charge, responsible or not responsible. Plea is accepted. 165, cashier end of the hall to your right, and I'll dismiss the original charge of prohibited turn. Any questions?
I feel payment plan better, please.
How much can you pay today?
75.
All right, when can you pay the rest?
Month so.
Where do you work?
DoorDash.
I'll let you pay $50 bi-weekly. How's that? Beginning on April the 14th. If you need more time, you come in here on or before any one of those due dates. I'll be glad to give you an extension, okay? So 75 now and then 50 bi-weekly. Best of luck. Tatiana Lungo. 26F245-764. Good morning, ma'am. Your name? I'm sorry, say that again? All right, so. You gotta slow down, ma'am. Okay?
Trying.
They've got you pleading to 1 to 5 over and they're gonna dismiss the 45 and the 25. Is that what you want to do? That's 1
Yes.
point.
Yes.
To that charge, responsible or not responsible? 160 is your total. I'll accept your plea. You gotta slow down though. Your record's looking pretty bad here, okay?
Yes.
All right. 160 and you can go down the hall and take care of that. Good luck. You're welcome. People against Kevin Robinson. Kevin Robinson, 26B149965. Good morning, sir. You're gonna plead to disregard a traffic control device causing an accident, is that true?
Yes, sir.
There were two people injured in this, is that right?
My understanding, yes.
All right, to that charge, this will be a traffic control device, or how do you plead, responsible or not responsible?
I guess I'm good, sir.
Responsible. Responsible?
Yes, sir.
Okay, I'll accept your plea. 195, okay?
Yes, sir.
Right down the end of the hall, you can make your payment. Best of luck to you. Thank you. All right, people against Muhammad Asghar, 26B 150517. Whoever's got.
First phone has got to get out.
Please, you gotta take the phones out, please. Thank you. There's signs all over the building. David Brush can come up to this table and have a seat here at my right, your left, and Nyquist can do the same. Your name, sir? This is Muhammad Cameron Asghar, 26B 150517. Your name?
Muhammad.
All right, so you are going to plead to impeding, right? You two have to be careful, okay?
I'm sorry.
To that charge of impeding traffic, responsible or not responsible? I'm sorry? I'll accept the plea. 170 is your total. Please be careful out there, okay? Thank you. How much do you have today?
50.
50? When can you pay the rest? I'm sorry?
End of the April.
End of April? Okay, no problem. April 30, okay? If you need more time, you call the court. We'll go on Zoom. I'll give you an extension. Best of luck to you. Do I have Tyler Nyquist here? He needs to have a seat at the table. David Brush, come on up here, 26B 150573. Your name, sir?
David Brush.
All right, good morning to you. You are going to plead to impeding traffic, correct?
Yes, Your Honor.
Responsible or not responsible to that? All right, 150 is your total. You got a clean record. I wish you well. 150. You're all set. Thank you. Tyler Nyquist, 26B 150574. Come on up to the podium, young man, please. Your name?
Tyler.
How you doing? What are you doing now? Are you in high school?
Yes.
Where at?
Whatever.
What are you gonna do next year?
College. Well, I have to finish high school first.
Why not? Just relax. I mean, in the fall, what are you gonna do?
I could go to Henry Florida Junior College because I'm going to take cybersecurity classes there.
Good. All right, so you're gonna plead to impeding. I'm not trying to make you nervous. I'll get you out of here, okay? For that charge of impeding, responsible or not responsible? Is your mom or dad here with you?
Yes.
Which one?
My mother.
That's nice to see. Thanks for coming, Mom. 150 is your total. Speed's dismissed. Slow down though, okay? You don't want to marry your good-looking face there. Good luck to you. Zachary Ostrowski, 26W841773. All right. Your name, sir? You're gonna plead to prohibited parking and they're gonna dismiss the expired plate, right?
Yes, sir.
Is that what you want to do?
Yes, sir.
All right, do you have a valid registration now?
Yes, sir.
Okay, to that charge, prohibited parking, responsible or not responsible?
Responsible.
You didn't have a valid registration at the time of this, though, correct?
At the time of the ticket, I did not have it resolved within the hour.
Good for you. You going to work?
Returning to work.
Where?
Romulus, fabrication plant.
All right, $85. You're out of here. Good luck.
Thank you, sir.
Have a good day.
You as well.
How about Scott Miller? 26B150229. Okay, it says both vehicles drivable, no accidents, no injuries, so charge is fair to stop a short clear distance. They're offering you impeding. Your name?
Scott Miller.
All right, just try to be careful, okay? To the charge of impeding, that's what you're gonna plead to?
Yes, sir.
Responsible or not responsible to that?
Responsible.
195 is your total, and you're all set and go down the hall and make your payment. Good luck.
Thank you. Have a good day.
You too, thank you. People against Trevor Gordon. Trevor Gordon, Trevor Gordon, 26W841760. Got you going 42 and a 25. They wrote you for distracted. Your name?
Trevor Gordon.
And now you want an informal?
Yes, sir. That's right.
Okay, I just want you to know, I might let the officer, if he asks me to amend the citation back to speeding. He was trying to be a nice guy out there. He wrote you for distracted. He's got you going 42 and a 25, which by the way is a 4-point. So I don't have a problem with you telling me you want an informal, but I want to forewarn you, if he asks me to amend the citation to go back to the original charge, I'm going to do it. Do we understand one another?
Yeah, I don't believe I was going in fast.
All you have to do is be going 26 and a 25, and that's 1 point. So I'm not quarreling with you. I'm just telling you, if he asks me to amend the citation, probably going to allow him to do it. He was being a nice guy out there. And these guys, when you start requesting hearings, that's fine. That's fine. You have the right to a hearing, but I'm just telling you, I'm going to let him amend the citation if he asks me to do that. Do we understand that?
Yes, John. Can I go back then
To the what?
to the citation that I was in?
To distracted?
Yes, sir.
I don't want to force you to do that. If you don't think you did anything wrong at all. But these guys are nice guys out there sometimes, and they give you a break on the road instead of writing you for what could have been a 4-point. He writes you for a 0 point that's not distractible. Do what you want.
I don't have a point, sir. And that was my whole point.
You don't get any for distract. It doesn't even, we don't even report it to the Secretary of State.
Understood.
So what do you want to do?
Take the strike.
You sure?
Yes, sir.
That charge of distracted driving, responsible or not responsible?
Responsible.
All right, I'm gonna accept your plea. Fines and costs are 155. I'll make it 150. You got a clean record. I'll cut that. Well, it is. It is. Good luck. 150 is your total. You can go down the hall and take care of that, and you're all set.
Thank you.
Best of luck.
All right, let's change things up. Fulton County, Ohio. We'll say good morning to Judge McBurney.
That's the on here.
Good morning, Mr. Kims.
Hey, how you doing, buddy?
I'm okay. How are you?
Oh, I'm okay.
Good. Mr. Kims, I'm Judge McBurney, and we are doing a couple things today. It's your arraignment day on your case. Ms. Rios, who has been doing a bunch of work on your case and has filed some things, she's already filed a waiver of arraignment, meaning she's entered a plea of not guilty for you. That means the prosecution's going to get discovery to her so she can talk to you about what evidence the state has. Ms. Rios has also filed a motion for a bond reduction, and that's what we're going to do. Since she's waived arraignment, I don't have to talk to you about the charges you face, although it may come up a little bit in the conversation we have about bond. But what we're definitely going to talk about is whether your bond should be reduced from what it's at now, and if it's going to be reduced, what's that going to look like? So we're going to get on the record in your case. This is 26 SC 000-598, State versus Kims. Mr. Kims is in court with Ms. Rios, his attorney. Ms. Willingham represents the state. And Mr. Kims, you were given a bond in September of last year, a $14,000 bond. But I don't know that part of what I would need to do, you don't have a bond at all on the kidnapping count. That's maybe part of the confusion. I don't know if Mr. Kims has tried to post the bond, but the bond he got in September, the kidnapping was dismissed, so maybe it was in connection.
From prison.
Okay, well, whatever it was supposed to be, what it is officially in the indictment is kidnapping. And you don't have a bond on that. You've got a bond for some other counts, but the bond and the indictment don't line up. So it may be that he shows in the system as no bond on something, but we'll address all that today. So it's $14,000 spread across some counts that some of which you don't face anymore. So let's work through all that. I'm going to hear from your lawyer. I'm also going to hear from the prosecutor. The prosecutor has asked for a little more time to see if Ms. Willingham, can get input from Ms. Smith. That's the person that you allegedly did these things to. We'll see what happens. Ms. Rios.
Yes, Your Honor. Mr. Kims is 47 years old. He's lived in Georgia for the last 7 years. Prior to being arrested, he was working at McDonald's as an overnight cook and a driver. He did graduate from high school, and he has 2 boys and 2 girls, ages 22, 20, 12, and 14, and he's an active father in all of their lives. He's been in custody for about a year now, and he's not able to make his bond, I think separate from the issue of him not having a bond on that case, that the bond is just too high for him to be able to afford. I do understand the nature of these charges, but again, at this point, there are allegations, and he's maintaining that this does not would happen the way the state is alleging that it happened, especially the kidnapping, since she did come to his location. That's the extent I'll probably get into with the facts, but I'm asking for the bond to be reduced to $5,000, and I understand that's low, but that's the most he would be able to hope to make.
Okay. And you don't think there's anything else holding Mr. Kims? No holds from other places? I don't see anything in the system. Okay. Tell me your understanding of the connection Mr. Kims has to Ms. Smith. Is this a stranger, ex-girlfriend? Not the mother of any of the 4 kids?
No, Your Honor.
Okay. All right. And Mr. Kims, where did you live? Ms. Rios said you've been in Georgia for 7 years.
It's kind of what backwards. I've been here since I was 7 years old.
Okay. So you've been here for 40 years.
Yeah.
Sorry.
Got it. That's okay. She got her wires crossed. All right. So you've been here for a while.
Yeah.
Got it. Okay. Anything else at this point you want to add, Ms. Rios?
No, Your Honor.
All right. Ms. Willingham.
Yes, Judge. I was gonna address the length of time that the defendant has been here. Because he has a lengthy history for the time that he's been here in Georgia.
Yeah, I'm just looking through the local jailings, and we go all the way back to 96.
That is correct, Your Honor. With most of the cases early on being simple batteries, but even in addition to those misdemeanor charges from the 90s, the defendant had an FTA in 1998. He had a violation of controlled substance in 2001, a probation violation in 2002, another one in 2005. Somehow he got a first offender for a drug charge in 2013, but that was discharged. It was successfully discharged. Not quite sure how the first offender happened though. And then when this incident occurred, he actually was under a sentence of 10 years to serve 2 years with 5 of those years suspended. He was sentenced in that case, and that was a drug charge. He was sentenced in that case on May 22nd of 2022. So our case would have actually happened during the time that he was still under sentence. And that case includes an aggravated assault. So the defendant has quite a lengthy history that includes violent acts.
Do you have the indictment number for that?
It is 20 SC 174292.
Okay.
It is not the same victim, but I would have some serious concerns about the defendant's risk to reoffend. As we stand here today, it's been a pretty consistent history with not many breaks. Oftentimes when we see cases where there's an old history, there's some kind of break. Here, it's pretty consistent from 1996 all the way up to present day, with the defendant having pretty consistent charges and several violent offenses. So the state would argue that the defendant is a risk to reoffend. And as I've already mentioned, we have not had direct communication with our victim, and that would also be a concern of ours if the defendant was released.
Okay. Mr. Kims, I didn't remember it, but your case from 2020 actually was a plea in front of me. You had Mr. Franklin as your lawyer and Ms. Hall was the prosecutor. You shot at someone.
Can I speak?
You're gonna get a chance to talk in just a minute, but you may want to preview to Ms. Rios what it is you're going to talk about. 5 to serve 2 years plus some probation. Okay. Okay.
And I'm sorry, Judge, I do want to add, he also has a simple battery out of Louisiana from 2015.
Okay. Does your file contain any input from Ms. Smith? I know recently you haven't been able to connect with her, but I'm curious if there are any notations of, hey, as long as he stays away, I'm okay, or the opposite.
No, Judge, I get all of our contact up until this point has been with her mother. I have spoken with her mom a couple of times, but I have not spoken with the victim directly.
Okay. And does her mom offer any perspective, sort of secondhand, as to what her daughter? Okay. Got it. Ms. Rios, your client had wanted to say something. Have you decided he shouldn't say something?
You're not going to say anything?
No. Okay. Anything you want to add?
No, Your Honor.
All right. So, Mr. Kims, I am, in light of reviewing the case you had a few years ago, concerned that something like this came up while you were on probation for that. And so I'm going to leave the bond as it is and let Ms. Rios continue doing work on your behalf. She's going to get discovery. Ms. Willingham, is there anything complicated about the discovery in this case? Any reason why you can't get it to Ms. Rios ASAP?
No.
Okay. So Ms. Rios is going to get the discovery in this case, which is going to be witness statements or body cam or whatever's out there. She'll review it. She'll talk to you about it. And then she's going to work with you on deciding what's the best way to move forward. Let's get here for a trial. Is it going to be a plea? Is there something that needs to be suppressed because the police did something that Ms. Rios thinks wasn't the right way to do things during their investigation? She needs a chance to look at discovery and talk to you about it, and we'll take it from there. Okay?
Yes, sir.
All right. Thanks, Ms. Rios.
Okie dokie. To correct the record, that was Fulton County, Georgia. Apparently, Ashley said I said Fulton County, Ohio. Nope, Georgia. Let's move from Judge Shouty Shout to Texas and say good morning to Judge Stevens.
Ashley Marie Stevens. Okay, you've been indicted as of November of last year for the state jail felony of burglary of a building. This carries with it up to 2 years in the state jail, and it's a felony offense, so it's serious to deal with. What's an initial appearance? What are we doing today?
Just put it on the announcement, Judge.
I'll just put it on announcement, Don.
Yeah, that's perfect.
Good idea.
Thank you, Judge. I appreciate you.
I don't see any other prior conviction. You don't have prior convictions here?
So, I think I'm not trying to work that out.
Fix this, okay? You know how long a felony conviction that you have to carry a felony conviction in this state when you're convicted? Do you know how long it lasts? Rest of your life. The rest of your life. So fix this. Okay, he's a good man. What else happened? Is that it?
That's not just
Okay.
one of them. But here,
You
look
did?
here, he is. You see the kids? Oh, that's all I had?
Well, hold on. Have a Caleb Puente at 9:30.
Do one more?
Right. Let me need to talk to him real quick. I'll come back to 9:30 online.
Yeah, and if there's something else, but I'm not really seeing anything.
I'm gonna do it on Miss Mays. I'm just gonna sign her up right now. Okay.
Where's that one?
Serenity Mays is 9:30, and that's gonna be a plea.
Okay, all right.
I'm gonna go sign up right now.
Okay. Don, Ebony, Chapman. Come forward. Ebony Chapman, come forward. 25 CR 1847 is called. You were Ebony Chapman?
Yes, sir.
All right, you're charged with state jail felony of theft. And because you have at least 3 prior theft convictions in county courts at law or district courts, anytime you steal a pack of gum, it's a felony from here on, the rest of your life. That's the way things work, because you're punished by the circumstances of the crime and your criminal history. It is always there. It always factors in. So anytime a penny you steal can be charged as a theft, a felony theft, and you're looking at least 180 days in state jail, up to 2 years in the state jail, and it's a felony conviction. It looks like you have one out of Calcasieu Parish back in 23, and then 2 county courts of law thefts. But nonetheless, anytime you commit a theft, it's felony from here on. That's the way the law works in Texas.
Yes, sir.
And go ahead.
This is her first appearance.
Certainly is.
I just visited with her a few minutes ago, and she would like a very short reset, 3 or 4 weeks for us to go over the information together. We do have an offer for probation for us.
3 weeks good?
Is
that right? How would it on that? 3 weeks, right?
Not before.
Yeah. Gotta be 4.
Okay, go back to Tuesday, please.
Angela?
On the reset, you can stick around. Yes. You can stick around outside if you'd like to talk with me. Okay.
You got a corner.
Sign right there.
How long did that?
Des Law.
Judge.
Are you representing him? No, Scott Rennick was hired yesterday, I believe.
Yes, sir.
I'm still.
Okay, you or Devin Deslaw, is that right? Okay, 20, this is cause number 26CR144. You're charged with a state jail felony of soliciting prostitution, which this one needs to be fixed too. You don't want to, this is not the kind of conviction that you want to carry around the rest of your life. That'll close off a lot of doors of opportunity. I see something, Scott Rennick is going to represent you. We just got this yesterday. Is that right? Is that what you did? Okay. Mr. Dusler here is a veteran, is a good attorney, but Scott is too.
There when you got here was right here for you to look at. I didn't think that.
Is he going to be here, as you know, if you know? Yeah.
I don't think it's gonna be very good.
All right, okay, we've done an initial docket, it's gonna be an announcement
Yes.
for him, in about 4 weeks.
Yes, sir.
Please get a resetting. Thank you.
Sign on the highlighter, that's for me.
Just, I need to see you just for a second, Mr. Deslon.
All right, let's stay in the building, but we'll go over and say good morning to Judge West.
Good morning, Ms. Burke. Would you please raise your right hand? Do you swear or affirm that you will truthfully and accurately translate from English to Spanish and Spanish to English?
Yes.
Thank you. Good morning. Good morning. Are you Hiberto Chavez?
Two.
Yes.
Yeah.
And Mr. Chavez is charged with deadly conduct, discharging a firearm. And cause number 25 DCCR 0559. And what is the announcement?
Judge, we're still asking for a little more time, trying to get through all the discovery, and he is, he's here at, thank you, LaSalle. And so there, that makes it a little more difficult to communicate with him. So if I could have just a little more time to get through that.
So what I'll do is one more reset. This will be the last reset for an announcement. If there's any issue with visiting at LaSalle or bringing a computer to show him things, if you'll just get with my staff, they can have him brought over and you can visit with him in the jury room. And bring your computer and show him everything so that we can get that all done before that next court date.
We can do that. Thank you. Appreciate it.
Perfect. So I'll reset it. Just get with them. We're kind of down quite a bit this coming month. So you'll have some time to go through that with him.
Thank you, Judge.
Yes, ma'am. No, we're going to start. I think just for time purposes, on Alan Bell, who we don't have, Ms. Malfino, Mr. Parker. So let me get that pulled up. Hold on. So I'm going in cause number 14-18993, I'm going to take judicial notice of the court's file. This is Alan Wayne Bell, who was found not guilty by reason of insanity, I think back in 2014. Or something like that, 15. Mr. Bell has signed a waiver of appearance for today. Let's see, that was signed and dated March 18th. And Mr. Parker, do you agree with going forward with this hearing without Mr. Bell present?
I do, Your Honor.
All right, so what I want to do though, so we received a report. Well, that's dated February 17th from the Rusk State Hospital, and that was sent by Dr. Holland. And their recommendation at this time is that inpatient treatment is no longer indicated at this time, and they have come up with a potential plan for Mr. Bell to be potentially released to a less restrictive placement. They sent me that information on what they're recommending. Hold on just a second. Let me find that. This is 34 pages long, but it's sorry. This is just all got JoJo and helps expedite it for you. So it's a community integration project.
I've got that same documentation, Judge.
And what I had intended for today was to have someone from the placement be here and testify about that specific placement so that I could get more information. I'm also would like to potentially done this in the past, and I think maybe might be warranted in one something like this, actually go to the placement. I've done that with the defense attorney and the prosecutor before on one where we took a trip and actually looked at it so that I could get a better feel on whether or not I felt comfortable with the level of, I guess, protection and how they're anyway, just what it looks like, so that I would know if I felt comfortable releasing Mr. Bell to this specific placement. And so since what I'm going to do now that we've started the hearing, we have some time constraints, I'm going to hold and carry the hearing forward. Ms. Carter is going to find out when we can have someone here, and we'll have just a hearing, quick hearing, so that on the record, they can say what level of care it is and how many people they have working there and the protections that they have if something goes wrong and he doesn't take medication and all those things, and then I'll make that decision. But in the meantime, maybe we can get together and I at least want to go lay my eyes on the place. And so if y'all want to take a field trip with me, we'll go do that and see where it is. And that way everybody has a little more information before we're arguing for or against it and things like that.
Just for the record, Your Honor, they've called me 2 or 3 times over this year since January, and
Who's that?
the facility where he is now.
At Rusk.
And basically, reiterate what you've expressed. And Mr. Bell, he's called me numerous times, and I've talked to him several times, and he's like, why am I still here? He said, why are you still there? And I said, we're going to have a hearing. When I talked to the facility, I expressed to them, I'm not an expert and I don't know his condition. I just got to base it off what they say, but that they need to talk to the court about coordinating whether they need to be at the hearing or Zoom in or something. So,
well, and what we'll do, obviously we have this, a very detailed report that they sent.
Right.
And if anyone would like any of the people that I guess had a part in that report and examination to make the determination that he potentially does not need to be there anymore. If you want any of them, they're easy to Zoom in. And so maybe what we can do is get them. I think we need to have everybody that we possibly can. And I've been, part of what I did in the past on one of these was actually go to Rusk itself. And so it is important. A lot of people think that, and there's part of Rusk that is very locked down. Where he is and the I can't remember what it's called, the unit that he's in is literally they could walk out. There's no fences, there's no locks, there's no anything. If you're in that part of it, you're already really easily in the community if they wanted to be. And so it was a little eye-opening to go there and realize that it's not such a stretch sometimes for them. If they've been in that, they've been in it for a long time. They were somewhere else in another unit for a long time. They have to prove things. I sign things all the time for Mr. Bell and some others to go on community outings. There haven't been any issues. And so it sounds a little sometimes scary, but where they are now and that unit that they're in is extremely, they have rules, and if you don't follow the rules, you get sent back to the other part. And so they have a lot of freedom. And he's been doing well apparently in that. So let's hold the hearing. We'll set it for in a week or two when everybody's available. And in the meantime, we'll get some more information about that place. Sure. All right. Thank you. Thanks. Ms. Perazzo on Traylon Hill. Morning, Judge. Morning. Don't need to look at it anymore. Here's your copy. I forgot to get back to you yesterday. Were you gonna say roses are red?
It's a coffee.
Please tell me that we're ready to go ahead and get it set for tomorrow.
So. There.
That was old, way old, and then he kept acting up. His offer.
Good.
Nice to see you again. You too. You got me quick, huh?
Good morning, you're Traylon Hill?
Yes, my wife was.
Good, and so, I'm going to take judicial notice of the court's file. The last time we were here, we wanted to double check and make sure that there were not issues with regard to competency based on some of the behavior and things that Mr. Hill was doing and saying. And so we had Dr. Rapon do a competency evaluation. I received that report dated January 24th. of this year. And in that report, the finding is that Mr. Hill is competent to stand trial. Is there any other evidence with regard to competency?
No, Your Honor.
None in regard to competency.
All right, then at this time, based on that report, I am going to find Mr. Hill competent to stand trial. Ms. Perazo, I know you are a little newer on the case. We've gone through some attorneys, but it is time for either a trial or a plea. So I need to know today if you want to visit with him in the back real quick. Whatever the latest offer is, if he wants to reject that, we'll get it set on the very next trial docket. If not, I want it taken care of this morning.
Yes, ma'am. And
I'll
if I
hold
could just
it.
get that offer.
I'll hold that. All right, go back with the bailiff.
Okay, I'll maybe give you in just a second.
Let's see, we have Thaddeus McCray.
How are you?
Okay, so we have now the new indictment.
Yes, ma'am.
Okay. And so we had the bond hearing on, right, already, is that right or no?
Well, it was,
I don't remember.
for today, before he was indicted, I was notified a motion to have a bond set. And then in the meantime, there he was indicted, and so I filed a motion for a bond reduction.
Okay, and is that in both cases? Or just the,
And the newly
the new-
indicted case.
We have a set bond, I believe, in the.
we have already,
We have not.
Have not, and so.
in the murder or in the MTRP?
In the MTRP.
MTRP, and so I don't know if that's going to
He's
be.
entitled to a bond on that one because it's a deferred. And then the bond should have already been set in the murder.
All right, so you're Thaddeus McCray.
Yes, ma'am.
And so, Mr. McCray, in clause number 21-38959, has a motion to revoke his probation, the underlying offense of aggravated assault causing serious bodily injury. And then we have clause number 26 DCCR 0399, which is the new indictment charging Mr. McCray with the offense of murder. Ms. Brazo has filed a motion asking that I reduce the bond in the murder case. And while we're here, we obviously need to talk about a bond being set in the MTRP case as well. And so the bond in the murder new indictment is set at $1.5 million. And then there's no bond in that MTRP. Is that correct?
That's correct.
All right. Are you, Mr. McCray, best you can raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you, Ms. Brazo. You may proceed.
Would you state your name for the record?
Right.
And we're here today on the motion to reduce your bond that's currently set at $1.5 million to $50,000. Is that correct?
Yes, ma'am.
If the court were to reduce your bond, do you have any assets that you could sell to make money to possibly make your bond? Do you have any means of making that bond that were reduced to $50,000?
Possibly.
Okay, could you explain?
Like just car, like I was just renting, things like that. So person I don't like own a house or anything like that. I do it on my.
Speak up. I'm sorry.
Oh,
I
speak.
have to hear you, and so does the
Sorry.
court reporter.
I don't own a house or anything. I was renting, but I do own my car.
Do you have?
So that'd be my own means.
Okay.
And then my other assets like clothes and stuff like that. So
What about family members? Do you have any family members that could potentially help you
that's
post your bond?
this is the possibility.
And are you asking the court if you are placed, if the court does reduce your bond, that you be placed on house arrest or have a GPS tracking device that would only allow you to leave your house for meetings with me, your attorney, or medical purposes?
Yes, ma'am.
Where would you be residing? That relates to my bond. If that were to happen. Where would you reside?
More likely I have to check with my sister.
Is that the only place that you would have to go?
Oh, now, but I know, my friend I know he's real busy. They both stay in Houston. So technically right now, I can check with some other family members. I know they all work and everything, and I have to talk to them first. I just can't say yes and voice into their on welcome.
Now, these family members, are they within Jefferson County?
Yes.
And who are the family members?
Sisters.
So you have a sister that is here locally?
Yes, and I have one in Dallas.
Okay, what is your sister's name?
Which-
That's here locally.
Oh, there is a couple of them, but Michelle.
I'm having a really hard time
Rochelle?
hearing.
Yes, that's one of them.
Thank you.
And what is, do you know her last name?
Her name is mine.
Okay, I was just making sure. Where does she, do you happen to know her address?
I just know she's staying in the West End.
Have you been in contact with her recently?
I talked to him, I got here, my father passed. Haven't really spent too much time on the phone unless it was like with my good friend, you know, I haven't really had much money to put on the phone. So, I mean, I was still in TRP phase, so it was really nothing for me to keep in contact with.
Okay, that's all I have, Your Honor.
Any questions of the witness, Mr. Smith?
No, Judge.
Any other witnesses with regard to the bonds?
No, Your Honor.
I am, for the record, taking a look at the probable cause affidavit and the new case. So give me just a second to go through that. Mr. Smith, what is the state's position with regard to bond in each of the cases?
I believe that the bond in the murder case is not set too high, and I believe that he is entitled to a bond in the MTRP because it's a deferred probation, but we would ask that a high bond be set in that. I believe we will be seeking to stack these cases, punishment in those cases. So we believe that he will be in prison for a significant period of time. After he committed the murder, he did flee the jurisdiction and was located in Houston.
Do you know how long that was from the time?
It was, I don't remember, it was several days or more.
Give me just a second. I'm looking back now at the previous pre-sentence report. So just to get an idea of what the underlying, hang on just a second. I'm on that.
If you recall, Judge, this is the case, we were in trial on the sexual assault and the state had rested. And when the state rested, the defense wanted to recall the victim.
Yes.
And the victim we were unable to locate to bring back.
Okay.
And so that was the reason that he pled to the aggravated assault rather than was sentenced by the jury to the sexual assault.
Got you.
Your Honor, if I could allow Mr. McCray to respond to the fact that, or to the statement that he was in Houston. If I may.
Sure.
Okay.
I was never in Houston. I never left this jurisdiction. I was found at my ex's house the next day. I never left.
And on Euclid.
Yes, I never left.
Okay.
So for me to flee, never left.
And that is correct, Your Honor. He was arrested at Euclid and there was some steps that were taken after that to search the residence.
Right.
And so forth. But it's my understanding from that point, which was either the next day or within a few days, he was apprehended there.
Okay. I think you have some misinformation on that maybe, or?
There was some info, I don't have the file with me, Judge, on that. I just remember some reading that they had suspected that he had been in Houston. But now that I think about it, we have found the motorcycle that was used in the murder.
There's no more.
You're thinking of,
Different.
you're thinking of a different case.
It was that one.
That's the other case of yes, I did. I apologize.
Yeah.
I'm getting confused.
Okay.
Do you have your file in this case?
I don't have it down here. It's upstairs.
Okay, so. On the offense date, okay.
Your Honor, also, if I may allow Mr. McCray to speak about this, since the underlying offense for him being placed on deferred adjudication, there were some allegations made as to what happened that he would like the court to be aware of. And I wasn't part of that.
That's all
case,
done
so I
on
just-
probation
okay.
for it, entered a plea of guilty to the aggravated assault. I was there, listened to the trial. I don't need any other information on that. So in cause number 21-3855-959, I'm sorry. Which is the motion to revoke unadjudicated probation. I'm going to set the bond in that case at $400,000. Condition of that bond, if made, is that Mr. McCray would be on house arrest with a GPS monitoring device. I'd obviously have to have an address locally where he would be. And then in cause number 26, DCCR 0399, I'm going to I'm going to grant the motion to reduce the bond. I'm going to reduce the bond in 26 DCCR 0399 to $1 million. Condition of that bond also, if made. A condition of that bond, if made also, is that you will be required to be on house arrest where a GPS monitoring device. We'll get the case set for an announcement, obviously, make sure, I'm sure there's a lot of discovery. Has all of that already been turned over? Is there anything missing?
I believe that we have received everything. I'm in the process of reviewing it. It's quite voluminous. So,
All right.
if something comes up, I'll let the court know.
All right, Mr. McCray, I'm sure Ms. Prazo will be out there to start going over the discovery with you so that we can see about getting an announcement which way your case will go at the next court date. All right, you can go back with the bailiff.
Thank you.
All right, friends, in our continuing efforts to provide you with 9 to 11% more, Judge Boyd, here you go.
Sis, hey.
I'm here because.
Oh, you're on this side. We'll figure out what's going on.
Okay.
Hello. How are you doing today?
Doing fine. I got these two things. I don't know if that helps you, Judge, from the probation office. I gave it.
We good?
All right. So on this one, does he owe any restitution?
Judge,
Because
the
it says
restitution is to be determined on both of those. I will get with the office to see if letters have been sent out and so forth. The issues that we're having with Mr. Glacy is, on one of his cases, he was placed on probation for deferred adjudication for 2 years. That 2 years is going to be up in July of this year. There are still some outstanding things that he needs to complete, defensive driving, GED, and then he just hasn't been in overall compliance with his UAs. We have not had a UA since July of last year. And
you're doing a UA today. What's the result going to be? All right. Why are you not doing your UAs? Do you want to go to prison?
No.
The range of punishment on these cases, on the case ended in 8-9, the range of punishment is up to 10 years in the prison. Do you want to go to prison? The other range of punishment on the case ending in 00 is up to 2 years in the state jail facility. If you get sentenced to 2 years in the state jail facility, that's day for day. Do you understand? Do you want to go to prison? Then you had better find time. And this thing about you're just not doing it, why are you not doing it? All right, so let me just tell you, this is the last conversation we're going to have about this. The next conversation we have, if we have one in regards to you're not reporting for your UAs, you're not making payments towards your financial obligations, what's going to end up happening, I'm going to see this, there's not going to be a compliance hearing. They're going to ask me what should be done. You see where that other is checked? I'm going to put file MTR. And then what will end up happening if a motion to revoke is filed, you'll end up being taken into custody. Police will arrest you wherever you may be. If you're about to have dinner, they'll arrest you right there. If you're in line to pick up your children, they'll arrest you in line if they find you there. And then you will be taken to the Bexar County Jail. You either make bond or not make bond. You'll either hire an attorney or one will be appointed for you, and we will hear the motion to revoke. And then if the allegations in the motion to revoke are found true, you're looking at potentially 10 years in one case and 2 in the other. Do you understand? You are not to miss another UA testing. Do you understand? And you're going to provide a UA today. Anything else?
Judge, the CSO is asking for his conditions to be amended to include the IVR hotline for 60 days, complete the aggressive driving course, and enroll in his GED courses within 30 days.
All right. Are you currently employed?
No, no, self-employed.
Huh?
I'm self-employed.
Doing what?
Mechanical.
So I don't even understand why you can't make these appointments. Because if you're self-employed, you make your own hours.
On the driving one, I'm doing that.
I'm sorry.
I'm
what?
already enrolled in the driving course.
The defensive driving?
Yes, ma'am.
All right, then you need to provide them proof of that because they don't have proof of that. And if you don't provide them proof, you might as well not have done it. All right, you understand?
And complete it.
Yes, sir.
And what is the issue with the GED?
I'm still looking into one of the schools, see if I could get enrolled.
All right, so here's the thing. With the GED, I'm going to give him a choice. He can either do the GED or go to a trade school, do something to improve his lot in life. Because I realize that sometimes the GED is more difficult for people.
Okay.
Well, I mean, sometimes it's difficult because I think they want you to do math. You know what I think I should do, Bashan? Before I leave, I should make defense attorneys take the GED test and see if any of them will pass. All right. So you're going to alternate main conditions. It's going to be the IVR hotline, or either you can do the patch. And you're going to provide them proof of your enrollment in the defensive driving course. Do you understand?
Yes, ma'am.
And you're going to take a UA today. All right.
The IVR hotline, how often do you want him tested?
Once a week.
60 days.
Let's do 30 and see how he does. I don't want to interfere with other things he has to complete.
The important thing is you have to finish this because your probation's running out and this judge will revoke you. You understand?
Yes, sir.
Okay.
All right. Thank you, Mr. Seeloff.
Thank you. I'll talk to the coordinator. That's why I was going to ask, what do you call it?
I'll just put it down as a motion to revoke hearing.
Okay, let's go back up to Michigan and Judge McNally. The smoker guy is still sitting there. Let's see if they do something with him.
26W841826. Morning, sir.
Good morning.
Your name?
Hiberto.
So they charge you with 75 and a 70. They think you were going 87 and a 70. They're going to allow you to plead to impeding. Is that what you want to do?
Yes.
That's 0 points. It won't go on your record. You understand that?
Thank you.
To that charge of impeding traffic, responsible or not responsible?
Responsible.
Plea is accepted, 155, cashier end of the hall to your right, and you're all set. Best of luck to you. All right, do I have everybody ready to go on James Martin? James Craig Martin, 24B 704583. Sir, your name? You gotta unmute, sir.
I believe he met with Mr. Haynes.
Yes.
Yeah, I'm calling right now.
You have to unmute in the bottom left-hand corner of your device there, sir.
Good. Oh,
There you
no,
go.
it's outside. Is that okay?
Yes, sir. Tell me your name.
Thank you, Your Honor. James Craig Martin.
We are going to get your lawyer in here right now. And I will have a hearing on this, okay? I'm sorry, you pled. Just wait till he comes in. We've called him.
Sorry, my grandson just woke up.
You're fine.
He's a bright spot in my life.
Good morning, Mr. Haynes.
Better call.
This is Mr. James Craig Martin. This is the moving violation causing death. 24B 704583. Okay, your name? Mr. Haynes?
Thurwood Haynes, we have James Martin.
Mr. Martin, tell me your name again, sir, please.
James Craig Martin.
He pled guilty to failure to complete the community service. That was alleged to have been 80 hours by November 1 of 25. I took his plea. And on January 15th, I adjourned the sentence to March 31. This has quite a history to it. He absconded after the plea was taken, but before the sentencing. And I gave him 120 days jail. I think I gave him 40 then and 70 out on house arrest, and also said he had to do 10 days of community service. Your name? So that is the charge. He pled guilty. What would you like to tell me on his behalf?
Judge, I looked at the history, it looks like, even though the offense did, it goes back to 2023, he didn't actually get sentenced till April 8th of 2025. So
Because he absconded.
still has some time with him. He's indicated he's got some severe health issues the last few months.
All right, hang on.
You guys gotta take the phones out of the courtroom.
Come on, guys. You can't. Was it
Sir.
you, sir?
Is that your phone going on?
It was you in the glasses, wasn't he?
Whose phone went on? Whose phone just rang?
Come on, guys.
Whose phone rang? What? Take it out. Signs all over the building.
So
Yep.
I never liked the idea of letting phones in here. Supreme Court told us we had to. They're supposed to be muted. We tell them that. They still come in here with the phones ringing. Every day. At least a couple, it seems like. All right, I'm sorry. I interrupted you. You started to say he's had serious health issues. I believe, I could be wrong about this. I think I adjourned the sentencing for 2.5 months so he could complete it because of health issues. Am I right or wrong?
That would track there, that would make sense, but still has enough health issues are all recently started to resolve. He indicates he could have everything done by June 1st.
Well, remember, we're not asking him to walk up and down the streets and pick up papers. These are sedentary jobs. Do you have something more substantial? Did we receive any medical records?
I haven't received any current medical records. He did send me medical records in the past. I do believe that he does have some health issues. I'm not discounting that, but I did give him 2 locations to go to, both that I know would help with sedentary work, which is Fish and Loaves and Victory Gym. I haven't looked that he's completed any hours, so I'm not sure where we're at with those.
Mr. Martin. And you were the one I just told not to be smoking. If you got some health issues, I'm not your physician, but what are you smoking for?
I smoke a few cigarettes a day compared to 2 packs a day. A few years ago.
Why are you not doing the community service? Did you hear what Ms. O'Donnell
I
just
just haven't
said?
felt well. I wanted to put it off till it was warmer, just to be honest. And I just haven't felt well enough to do it, and I ran out of time. I paid for the the course, the decision-based driving. I paid for that, but I still have to do it because they only do it every 3 months. I scheduled that a few weeks ago, and
No, but I placed you on probation in April of 25, April the 8th. Why is it taking you so long to do everything? I mean, I gave you until November 1st, probably again because of the health issues, to complete 80 hours of community service. And you had till November 1, then you didn't do it, then we show caused you, then you were in here in January. I gave you 2.5 months before I would sentence you. She tells me she sent you to 2 different places that she's confident you could have done the work at. You still haven't done it. Where's your medical records? Where's your medical records? Have you sent us any? Have you sent us any?
Yeah, you guys have my
I
medical
records
records.
from in the past, but current in the last couple months here.
I just want you to know I just filed for Social Security, and not feeling well is probably something you hear a lot, but I
don't know who's talking in the background, but they can't talk and tell you what to say. That's not gonna go.
I don't feel good. Just plain and simple, I just don't feel well. My heart hurts the whole time.
Okay.
I did contact Fish and Low. I know
When
what I
did you
gotta do.
when did you contact Fish and Loaves?
That was probably Saturday, I think.
Because you knew you had this coming up, right?
Well, of course, I wanted to at least pay for it. I think that's the wrong one.
Heather, give me a date the first week of May, please.
Sorry, Judge, I was muted. May
That's
6th.
May 6th at 8:30 in the morning. I'm gonna expect you to have that done. If you want to go to a doctor and get us proof within the next 3 or 4 business days that the doctor's telling us you cannot do the sedentary work at any of the 2 suggested places by Ms. O'Donnell, I'll be more than happy to give you more time. Okay, so you better go to your physician real quick and get us the medical records and a report saying you can't do the sedentary work at Fish and Loaves, or where's the other one? Victory Gym. No problem. I don't want you to do anything that's going to jeopardize your health, but it seems like you're putting it off. So that's what I'm going to do. May the 6th, 8:30, I'll expect it done unless you get us medical records here in the next few days and you request a hearing, okay, for an extension. Do we understand one another?
Yes, Your Honor.
All right. Good luck to you. Thank you.
Thank you.
All right. Derek Tanbelda for an.
And now we know the story of Smoker Man. He doesn't feel well. He always hurts. His heart hurts. And he has excuses for everything. Pretty standard, really. Looks like Ashley's going to follow him, so we'll keep track of him in the future. Let's go back to Texas, Judge Stevens.
Complaining as well, Judge.
I mean, matter one offense, why you don't blind, and there's another. A second charge, you got 2 charges against you. 1, 2, he's not.
Can't make some of this stuff up because it's. Shooting on. Looks like. Now, okay, we've got 2667 and 26 CR 408. 2667 is an indictment handed up by the grand jury on January 14th of this year. And then the second one comes about on March 18th of this year. He's posting a bond in the 2667, he's posting a bond on 1/28/26. But the second event is occurring on January 11th, which would have been 2 weeks before. Yes, sir. So. I don't disagree that it's the same victim. But it makes no. A warrant was issued for him. His arrest on January 14th, and that was 3 days after the second offense occurred. Yes, sir.
And Judge, I'll be having to ignore that stuff.
Okay. Okay. All right, so let's get this straight. Don't look like I can't believe it's not butter. Look, you know what you did. You know it. Well, you think you're going to commit a crime and there's not going to be a warrant issued for you? You've been charged with stalking in the second case. And don't act like that.
I'm just trying.
So you've got 26 CR 67. This is an indictment for assault family violence, which alleges that on or about November 25th of 2025, you caused bodily injury to a member of your family. It's a member of family, household, or in a dating relationship. And it is a dating relationship, so according to probable cause affidavit. But this indictment also says on December 8th of 2017 in this court, you were convicted of assault involving family violence. And the next paragraph of this indictment also states that you were finally convicted of assault on a family member, a third-degree felony, on September 12th of 2018 in this case, in this court. That's a different cause number. So this third-degree felony in 26 CR 67 is now bumped up to a second-degree felony punishment because of your prior conviction for assault on a family member. So you're looking at 20 years in prison. I've only done one. We're going to go to the second one now. Then, January 11th, you're charged with the third-degree felony of stalking, and that prior 2018 conviction in this court is alleged assault on a family member. And so this third-degree felony also becomes a second-degree felony punishment. So that's 40 years you're looking at in prison. No, it's not a debate. It's what the grand jury indicted you on. So they indicted you on an event that occurred, which states that with the intent to harass, annoy, alarm, abuse, torment, or embarrass the other person. You made repeated phone calls and electronic communications to the complainant, which was an attempt to, was only intended to harass, annoy, abuse, and torment. To repeatedly ring and electronically notify them that causes somebody alarm. And they would feel harassed, annoyed, alarmed, abused, tormented, embarrassed, and offended. Any lady would. You start acting like a man, a gentleman, a man, not tormenting women. That never played out well when I grew up. Picking on girls. Needs that, start acting manly. So you're looking at 40 years in prison in all of this. Serious. Couple of things. What are your bonds in this cases? I see a $30,000 bond in one of them. First.
Warrant upon having consent.
Oh, okay, that's the warrant. Okay, you're gonna be taken into custody here. Because there's a warrant for your arrest on this second indictment of stalking.
I was trying to figure out when was that?
Of January 11th is when that occurred. On or about January 11th. The other one is on or about November 25th.
When was the indictment drop?
Huh?
When was the indictment drop?
Indictment drop, what do you mean? Handed down? Oh, on March 18th, 2 weeks ago.
Oh, okay.
All right. So you're gonna reset this.
Yes, sir.
These two.
And also,
For an announcement in 4 weeks.
he also advised me of some more that he's working with hiring an attorney in Houston for representing. So I think for this would be appropriate to let him get to take care of all that.
And stand by. First one, this.
What you looking for?
The problem cause that.
On the stalking?
Here. Oh, November 25th, okay.
That's the original charge, Judge.
Mm-hmm. Okay, so a probable cause affidavit has been filed on November 25th on that first case. The day apparently the day it happened, the police investigated it and then wrote a report.
PC on the stalking is dated February 11th, Judge.
And there was a warrant issued for him on November 25th. There was a warrant on you on February 25th. I'm sorry, November 25th, November 25th. He was arrested.
Okay. Okay, it'll know to me, sir.
See what it says.
He hopes the bond was something January 28th. But he had already, was a case already filed. May or may not have known about it, but nonetheless. What's his, is there a bond pending on this 2640N?
No bond.
One has not been set,
All right.
the warrants are pending.
All right.
It's up to you, Your Honor. I will advise on the first matter, there is a no contact and a protective order is actually in place as to both calls numbers. And a GPS device was ordered on him as to condition of bond on the $30,000 bond on 0067.
But that was all after this second event, though, right?
Yes, sir.
Okay.
Yes, sir. So I don't have any evidence to suggest that that's not working, but at the same point in time, I want to ask that the court consider the appropriate bond that Your Honor feels is proper.
It's 30.
But to make sure that the same conditions of the GPS device and the no contact exist on 408.
All right, it was 30.
Yes, sir. Yes, sir.
Okay. You're going to be taken into custody. There's a warrant for your arrest. Bond is $30,000 on this second as well. Once again, you can't commit crimes, felony crimes, especially involving a situation like this, this relationship. And also you must have a GPS device that you have no, this is the most important thing. No contact with this person, the victim, nor anyone on your behalf.
That's what I'm trying to do.
It's not a debate, just listen. Nor anyone on your on your behalf, contact her. I don't want to find out. The DA's office will tell me if you attempt to contact her or somebody on your behalf, then we'll race you in here as fast as possible. Your bond will be revoked and you're going to sit out in the county jail until these two cases of where you're looking at 40 years imprisonment on both of these together get disposed of. You understand? Those are the marching orders and they will be firmly dealt with.
One matter, Judge, since the court had ordered a GPS device on him and prior to this incident, can we affirm that he actually has it in place?
You have the GPS on you?
Yeah.
On your ankle?
Thank you, Judge. I appreciate
That always has to be monitored at all times. You just don't wear it. It also has to be monitored through we've had somebody shows the device, but it wasn't being monitored.
Oh, no.
And when that happens, that's just like you don't have a device. And if you pull a stunt like that, you'll go to jail. Okay. All right. Get a resetting, also done, 4 weeks?
4 weeks, yeah.
Okay.
Yeah.
Can I give this to me?
Alrighty, friends, about 45 minutes to go. Again, doing a 3-hour show today instead of 4. Let's do something different. Let's go back to the 14th Circuit in Florida, but this is Bay County first appearances with Judge Tracy Smith, who I personally have not seen before.
On the record this morning. Good morning, everybody.
Morning.
It is March 31st, 2026, and we are here for first appearances. I see some attorneys in the room with me as well as some other individuals. So if the person that you were here for, once they are on the screen, when you see them, if you will get my attention or my bailiff's attention, if there is something you would like to say in regards to bond, not about the facts of the case or anything that happened, but in regards to bond, get our attention and we will listen to you at that time. All right. Good morning. I see Mr. Griffiths. I've got the state attorney's office in the room with me. Good morning, Ms. Fambro.
Good morning.
All right. Who do we have first, ma'am?
State your name, sir.
Joseph Duggar.
Good morning, Mr. Duggar. You're here for your first appearance after being arrested for the second-degree felony of lewd and lascivious conduct by a person 18 years of age or older. You're also here this morning for your first appearance after being arrested for the life felony offense of lewd or lascivious molestation by an offender over the age of 18 years of age and a victim under the age of 12. It's my understanding, sir, that you were given a copy of your paperwork and advised of your rights at the jail. Is that correct?
Yes, that's right.
Right, sir, I reviewed the application that you filled out, and it says that you do not want the court to appoint an attorney to represent you. So I will not do so at this time, sir, but if you have a change in circumstances, you can fill out another application for the court to review then, okay, sir?
Okay, thank you.
And Mr. Saleen, are you here this morning on behalf of Mr. Duggar?
Yes, Your Honor, I represent Mr. Duggar in this matter. Your Honor, the family is asking for the most reasonable bond. The court is inclined to extend. It's my understanding he has no prior criminal history whatsoever, not even a speeding ticket. His father has flown to town on Saturday and is here in our community, ready to post a bond if the court is inclined to issue such. So we're asking the most reasonable bond the court is comfortable in setting, and has to be treated as fairly as anyone else would, regardless of his status in the television industry.
Mr. Saleen, are you representing Mr. Duggar for first appearance purposes or through the duration of the case, sir?
Through the duration, Your Honor.
All right. Anything from the state attorney's office?
Yes, Your Honor, good morning. We're asking for a substantial monetary bond in this case. It's a serious charge against the child. We ask that there be a no contact placed with the victim, as well as no supervised contact with any minors. Mr. Duggar, even though he doesn't have a criminal history, has no ties to the community. The alleged facts here was that he was just on vacation and stayed here a short period of time. Same ability to come here a short period of time allows him to leave quickly as well. So no ties to the community. So we ask for a substantial bond under 903-46 factors you're allowed to consider to make sure he appears in court.
All right. And another judge determined there was probable cause for your arrest by signing of the warrants. Ms. Fanbro, do you have any criminal history, ma'am?
They show a child endangerment and false imprisonment out of Arkansas this year.
Your Honor, I believe those are charges that may still be pending. As you know, he has another family member that was arrested for the same circumstance. I don't think those have been resolved in light of him coming here.
Mr. Saleen, I'm not aware of anything else, sir. I'm just here this morning on Mr. Joseph Duggar's case. So, so Ms. Fanbro, you show those as open, you said out of the state of Arkansas?
I don't show the disposition. I show that they were charged.
Okay.
That is correct. There are pending charges in Arkansas at this time.
All right, Mr. Duggar, I'm going to set your bond amount this morning in the lewd or lascivious conduct charge at $100,000. I'm going to set your bond amount in the lewd or lascivious molestation charge, which is a life felony, at $500,000. It's a total of $600,000 bond. Sir, you're going to have some other conditions as well. Sir, you are ordered to have no contact with the alleged victim. That means directly, indirectly through a third party or social media. Do you understand the no contact order, sir?
Yes, ma'am.
Sir, you are also ordered that you are to have no unsupervised contact with any minors under the age of 18. Your next court date, sir, is April 20th at 9 a.m.
Step to your right to the T. Ma'am, if you'll give us a moment.
Yes, ma'am.
And Your Honor, that's all I have. Maybe excuse me.
Yes, sir. Thank you. Have a good day.
Yes, Your Honor, and same here, if I may be excused.
Yes, sir. Have a good day,
Thank you,
Mr.
Judge.
Saleen.
Have a good morning.
I was like, it's habit to reach over here. Did you need something, sir? Oh, okay. That's gonna be hard not to reach over here. That's okay. It'll take me a few, but I'll get it. Morning.
Okay, I normally don't hit pause, but just to bring everybody up to speed, yes, this is the Duggar family from 32 Million Kids and Counting, or whatever the hell show that is on the trash TV network. Bay County, Florida. The Florida charges: Joseph faces lewd and lascivious molestation of a victim under 12 and lewd, lascivious behavior by a person 18 or older. He and his wife Kendra face 8 criminal charges back in Arkansas, 4 counts of second-degree false imprisonment and 4 counts of endangering the welfare of a minor related to a separate police investigation. So you never know what you're going to stumble into here on TCF. I wasn't planning on it, but this is why you watch us every morning. Anywho, let's finish off this docket. I guess that docket's done. All right. That was all there was to it. Let's go Judge West. Let's go there.
Ian Adams. And this is cause numbers 23 DCCR 0492 and 0493. Mr. Adams is on probation in each of those cases for deadly conduct, discharging a firearm. There have been motions to revoke filed in each of those cases. And what is the announcement?
Judge, Mr. Burbank had requested the videos from the underlying misdemeanor cases that make the basis of the motion. We had sent through the online portal the link, and he informed me that it didn't work. So we'll have to physically copy those from them.
Okay, so one reset, you should be able to get that done, go over it with Mr. Adams, and we'll get an announcement, you think?
I mean, we were going to plead, you didn't want us to plead to some of the counts, some you wanted to announcement on all of them. And
Right.
Video, Judge.
So that was. When was our last, was that?
It was
30?
about 3 or 4 weeks ago, Judge, and I was in trial. Mr. Burbank was in trial and had a wedding. And I followed up the last few days, trying to get the thing copied. I was informed that's on this online portal, so we sent the link, and then found out it didn't work.
Okay, so I'll do just a normal reset, make sure y'all get it taken care of.
We'll just have to do it the
soon as-
old-fashioned way and get it to them.
Okay, if you'll get whatever they need, I don't know if they'll need a thumb drive, get whatever they need, and so we can get an announcement at that next court date. You can go back with the bailiff. Mr. Burbank, you have Elazar Stansberry. Stansberry. Good morning. Are you Elazar Stansberry? Eleazar, and Mr. Stansberry is charged with murder in cause number 26 DCCR 0174. And it looks like Mr. Burbank has filed a motion asking that that bond be reduced. It's currently set at $500,000. Mr. Stansberry, best you can, raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? All right, thank you, Mr. Burbank.
For the record statement.
Eleazar Stansberry.
Eleazar, we're here to request a bond reduction, is that correct?
Yes, sir.
It's currently at 500,000.
Sir.
Do you have any bank accounts with any substantial money?
No, sir.
Speak up.
No, sir.
And do you have any IRAs, retirements, any type of property that you could possibly put up as collateral?
No, sir.
You were asking that the bond be reduced,
Yes, sir.
and so that an amount that you'll be able to make, is that correct?
Yes, sir.
You have, if you are able, if the bond is reduced, will you be able to stay in the area?
No, the last time I came, Miss West told me I can go to girlfriend's house in that Harris County.
All right.
And so that's where you'll be staying.
Yes, sir.
You know that you would have to get a GPS device.
Yes, sir.
And there'll probably be some rules and regulations, I believe, that the judge probably set for you. In reference to where you could go and where you couldn't go.
Yes,
And would you comply with those rules?
yes, sir.
Your Honor, before I was court appointed, I think Ms. Holmes asked for a bond reduction.
I don't see that there was a motion.
No,
That's what I was looking for.
yeah, I mean, I went out there. I went out to see Mr. Stansberry, and in between there and Ms. Holmes, I guess he was on a docket or something, he requested that it be reduced, and reduced it down to 500,000. Before,
So what's changed then? If I've already reduced it?
since then, yeah, since then, he has tried the 500,000. This is my first bond hearing, Judge, and I don't know why he got in front of you before, but it did.
Yeah, I see that it was initially set at 1.5 million,
Right.
reduced to 500,000.
We're asking Judge that it be reduced down to 150, 175.
Mr. Nichols?
I see no reason the bond should even be at 500, Your Honor. Besides this case, he has a weapons charge also pending that predates this murder, a misdemeanor involving firearm. He's been in fights in the jail. He's done nothing that would, I don't understand why we got down to 500, to be honest, Your Honor.
Well, and I don't recall, and I don't see anything in the case on that either. So, yeah, I think at this point, based on the nature of the offense, I have taken judicial notice of the court's file, which includes the probable cause affidavit. There's not a whole lot of information in it, but enough that I believe that based on the offense charge, the fact that there's already been a bond reduction and what Mr. Nichols has provided with regard to another underlying weapons charge, I'm going to deny the motion to reduce the bond any further at this point. So we'll reset a case and get it for an announcement as quickly as possible.
If we could, Judge, we'll be able to announce it.
All right, thank you. You can go back with the bailiff.
Thank you.
Thank you, Your Honor.
That's so weird that there's nothing.
All right, let's go up to Huron County, Michigan, Judge Prill, who appears to be remote this morning.
FH. The defendant appears via the Zoom application. She's currently lodged in the Huron County Jail. For this proceeding, represented by attorney Tammy W. Salins, who is in the courtroom. The people are represented by prosecuting attorney Timothy J. Rakowski. The defendant is before the court based upon a bench warrant that was issued for her arrest for allegedly failing to report to a probation violation arraignment back on September 22nd, 2025. That motion affidavit, as well as bench warrant, was authored by, actually the bench warrant was authored by prosecuting attorney Timothy J. Rakowski. The original probation violation document alleging that the defendant violated probation contains 5 counts. And it's alleged, and this was an amended motion filed on September 10, 2025. It's alleged in 4 technical violation counts that the defendant failed to complete any outpatient residential substance abuse treatment as of August 27th, 2025, as well as failed to complete domestic violence programs, as well as anger management programs. Also, count 4 alleges that she had failed to comply with the employment provisions previously ordered in the original order of probation. Finally, count 5 alleges failure of the defendant to report to the Lapeer County Probation Department as of September 3, easy for me to say, September 3, 2025. The first 4, as stated before, are alleged technical violations. Count 5 is an alleged non-technical violation. As a result of an alleged non-technical violation, the defendant could serve up to 5 years, strike that, 2 years in prison, minus any time served to date. Ms. Salins, have you had the opportunity to speak with your client regarding these allegations, as well as the advice of rights form that you normally have prepared in this matter?
I have, Your Honor.
And she understands everything?
She has indicated to me she does, and she did sign the advice of rights form.
All right. Ms. Phillips, would you please raise your right hand? Do you swear or affirm the testimony you're about to give will be the truth, and nothing but the truth?
Yes, Your Honor.
Thank you. Please put your hand down. Please state your name for the record.
Cheyenne Phillips.
Ms. Phillips, you have had the opportunity, and I'm not doubting Ms. Salins, but I just want to cover the record. Have you had the opportunity to speak with Ms. Salins about all of this?
Yes, Your Honor.
And you went over the rights relative to the probation violation rights form?
Yes, Your Honor.
And you signed that document?
Yes, Your Honor.
And you understand all those rights?
Yes, Your Honor.
All right. And as stated, you are entitled to have a probation violation hearing where it must be shown by a preponderance of the evidence, more likely than not, that you violated the terms of your probation. Do you understand that?
Yes, Your Honor.
And beside all the rights contained on the advice of rights form, you have the right to assistance of counsel, and it would appear that you are eligible for court-assisted counsel. Hence, one will be assigned to you after this proceeding. But you understand the charges made against you?
Yes, Your Honor.
All right. Ms. Salins, how does your client plead at this time?
She stands mute.
Very well. Not guilty pleas will be entered on behalf of the defendant relative to all 5 counts contained within the motion, affidavit, and bench warrant. And the bench warrant is hereby recalled. Ms. Alexander is in the courtroom. Ms. Alexander, are you requesting a bond in this matter?
I'm requesting no bond or some sort of high cash bond at this time.
All right. Allegedly, when's the last time she's had any contact with the probation office?
That would have been the 9/3. I apologize. I don't have my computer in front of me, but it was.
Would it 9/23 of 25 as alleged in the documentation?
I believe it would be somewhere in between there. That's correct.
All right. All right. Ms. Salins, do you have any comment relative to a bond in this matter?
Your Honor, my client has indicated to me that she is receiving public assistance, that she has no money available to post bond. She has no objection to the court setting a bond in a reasonable amount, but it is her intent to remain incarcerated so that she gets credit for the time she's incarcerated.
Thank you, Ms. Salins. Mr. Rakowski, your position on bond, sir.
Yes, Your Honor. Discussed the matter with adult probation. My understanding, Ms. Phillips had a conversation with them after she's turned herself in, indicating she had used meth in the past year. She's been clean for a little over a month, but our concern is that if she gets out now not using and then back using, that she would harm herself. So we're asking for a bond of $20,000 cash.
All right, thank you. Considering comments of counsel as well as the alleged statement, or I shouldn't say alleged statements, regarding the statements and allegations that the defendant has been AWOL since September 23, 2025, court is going to set a cash surety bond in the amount of $50,000 cash surety. Ms. Salins, anything further on behalf of your client?
Your Honor, my client has indicated to me that she does suffer from a very, very serious mental health issue. She is on medication. Her medication is with her right now at the jail and is being dispensed. However, she did miss her appointment with her psychiatrist because she was incarcerated. So I would request that a call be made to possibly Huron Behavioral Health, just so that they can check in on Ms. Phillips to make sure that she is stable.
Very well, thank you. Mr. Rakowski, your position, sir?
We have no objection to that. I would ask the court, are we going to set the hearing then for the 14th or 13th?
April 13th.
April 13th?
Yeah, we need to set it within 14 days of today's date, as she is incarcerated. Is that date acceptable, Mr. Rakowski?
Yes, Your Honor.
Ms. Hatch, who would be the attorney assigned to this matter? Do you have any idea?
Yes, Attorney Weisenbaum.
Elizabeth V. Weisenbach will be appointed, assigned to represent the defendant. Court will also order that, well, actually not necessarily order, but I'm going to order that Huron Behavioral Health be contacted so that the defendant will have the opportunity to meet with them regarding any issues relative to mental health treatment. And Lieutenant Newman is very good at the jail, making sure that those matters are addressed. So just a simple phone call, Ms. Hatch, would be greatly appreciated to Lieutenant Newman so he can be given heads up on this so we can proceed accordingly. Anything,
Okay.
record, please?
No, Your Honor, thank you.
Ms. Salins?
No, Your Honor.
All right. Thank you. That will conclude the proceedings. Thank you. Off the record.
All right, friends, let's go back down to Texas and Judge Boyd.
We go way back.
Oh, hey,
How you doing today?
you know, in the words of Principal Ava from elementary, do y'all go back to molars?
No, not quite that far.
All righty, so what are we here for with Mr. Lorenzo?
Mr. Garcia has an occupational driver's license application that's pending in front of the court today.
All right, can you have them pull that? Because they didn't,
The application, I've got the application and a copy of the order if you need. Just,
have you conferred with the state?
I have. I conferred with Mr. Prater yesterday on this case. And the state is silent. They don't have a position one way or another. This is a felony DWI, so there was a waiting period that we had to go through. He was placed on probation, what, over a year ago, right now? Year this month. And so he's gone through the waiting period. And so we wanted to do an application. Uber fees are killing him.
Okay.
And so he is anxious to be able to at least go to work and drive to work. He still has ignition interlock. We got contacted by Barbara last week, and she asked us to provide her the proof of the ignition interlock with the latest calibration for this month, which
Okay.
we did.
Okay.
And so he's in full compliance, Judge. We just are trying to get him an occupational license so he can.
Okay, so it's required that we have hearings on these. So we're gonna go on the record with this hearing. And it appears from my review of the application, everything appears to be in order. The main thing is having the ignition interlock and having insurance. So if for some reason, if your insurance ends up lapsing, then you know you're not allowed to drive. All right, we're gonna go on the record. The court is calling 2026 CI 05308 N. Ray Lorenzo Garcia for the defense
David McLean for the defense.
and for the state. All right, this is a request for, I should say, an application for an occupational license. The court is required to have a hearing. Defense, you may proceed.
Thank you, Your Honor. Your Honor, this morning we have the application for an occupational license. This is for a felony DWI. My client has completed the requisite time before applying for this license. And so the application is timely now. He has provided attached to the application proof of insurance, his certified driving record, which shows that he has not had any other violations or anything since being placed on probation. He currently has ignition interlock in his car. We provided proof of that to the staff attorney last week that has a current calibration and a current fees paid. He is willing to comply with all the requirements this court would impose on him. He just is requesting that he has an application for this occupational license so he can go to work, attend probation, attend court if necessary, go to church and take care of his basic needs.
All right, state. Oh, if you can come forward though, please. That's okay. All right, if you could sign here, this, you're silent, but this is just approving the form in which it's in. But. All right, so I'm going to grant your application and sign the order. Make sure that you have a copy of this with you at all times. You understand? And read over it because you're only allowed to drive during the times that's presented in the application and in the order, okay?
Yes.
Do you have any questions about anything? Thank you.
Of course.
Okay.
We're going to get certified copies of this right now. Okay. Judge, thank you so much.
All right, you're
Appreciate
welcome.
it.
Thank you.
Be excused.
Yes, you're
Thank you,
excused.
Your Honor.
All right, let's head back over to Judge West's courtroom.
It's, are you, are Larry Fitzgerald Williams?
Yeah.
And Mr. Williams is charged in cause number 25 DCCR 0985 with capital murder. And Mr. Cash, it looks like filed yesterday, which is, we're here just on an announcement, I believe, but filed yesterday, a motion to compel the state to declare their intent to seek the death penalty or not. And Mr. Smith what is the state's position? Do y'all have one yet? I think that's obviously very important at this. This is from a murder from June of 2025. So if it's not been declared, I think it's time. I would agree.
Well, as far as I understand the law, Judge, the punishment for capital is the death penalty unless the state waives that. We've not waived it yet.
I understand what the law is. I also understand that the case needs to be set up a whole lot different from the court's perspective. If we're going to set this for trial, then we need 6 or 7 weeks. From Mr. Cashin's perspective, he's got a very different potential strategy and mitigation and all of that kind of stuff if we're going to go. And so I don't disagree that the state needs to make that decision. It's time for all of us to be setting it for trial or working something out. And if I'm going to hang on, if I'm going to set it for trial, I need to know what I'm setting it for trial for. So here's what I'm going to do. I'm going to reset the case, one reset for you to meet with whoever you need to meet with. I am going to order that there isn't an answer because we will be either setting it for trial or it'll be the end of the announcements. It's either going to be worked out as some type of plea or we're going to be setting it for trial at that next court date. And I need to be able to know what I'm setting it for. So get with whoever you need to get with. Let's get an answer between now and then so that we all know how to go forward. Since we're at that point, we'll be 10 months out. So it's time to figure out what to get it set for. So I'll reset it and we'll get that at that next court date. All right. You can go back with the bailiff. Yeah. I need to know once you set that date, I need to build in right there so that I need that sent to everybody. Mr. Crocker, you've got Caleb Laskowski. Good morning. How are you? It's been a little while. Make it out of the country to the big city.
And I have to go back. We did.
Good morning, you're Caleb Laskowski, and this is 21-37917, and Mr. Laskowski has a motion to revoke probation underlying offenses evading arrest and detention with the use of a vehicle. And what is the announcement?
Your Honor, you'll note that this was filed
2022.
22.
Yeah, so
He subsequently, after part of the basis of the motion was 2 convictions out of a different county, and he went and did time on those. And so we can either if the court's inclined to take our pleas to the allegations contained in the state's motion, we can do that. Or 2, I can figure out how much time he's got. It matters to the court.
well, have you talked to Mr. Smith?
I haven't.
Okay, I'll hold the case. Y'all visit about it because it may be that y'all can get that information and get an offer and work it out this morning.
My fear is it's going to be scattered across a couple of counties and a couple of state institutions. It may not be readily ascertainable.
She's looking to see what she can find out, but y'all talk about
Okay.
possible whatever y'all can. Talk to Mr. Smith.
I will.
Ms. Warner can work on credit potentially, and then we can see if we can get an announcement.
I think you can call.
Mr. Galmore. And Mr. Johns didn't come today for that one. Ma'am? Yeah, he was on Williams, so. Marvin has got quite the docket today.
All right. All right. Well, she looks for another contestant. Let's go across the hall to Judge Stevens.
Starts with burglary of a building, which again carries with it up to 2 years in the state jail. And are you talking to some lawyers? Are you talking to some lawyers? Or you're not going to represent yourself in this? No, that's why we have lawyers. That's why God invented them, to help people in legal matters. So you need to go talk to some people and talk to them. You understand? Are you working somewhere? You have a soft voice. Where were you employed?
At the Lindy project.
At the where?
Across from the prison.
What were you doing there? What was your job?
I was just,
A what?
flagger.
A flagger? Wow. So you need to talk to some folks about representing you. If you're unable to afford someone to represent you, two things. We can get somebody appointed to represent you. Number two, you can't afford to be in criminal trouble. So I don't see any prior convictions. You've never been convicted before of something? Well, this is up to 2 years in the state jail, and it's burglary of a building. A felony conviction follows you around the rest of your life. That's why you don't want one of these. I'm going to give you 3 weeks to talk to some lawyers and see if you can hire somebody. If not, you come back and tell me what happened, and then we'll see what we do from there. A couple of things. You posted a bond. How much is your bond? Well, who posted your bond? Somebody else, I guess. Somebody else paid for it?
Yeah. Well, no, like I'm paying for it weekly. They put me on a payment thing.
These aren't hard questions. You sound confused.
I just don't remember him.
Yeah, it's a $15,000 bond. So you're going to be paying at least $1,500 for that.
Yeah, I have $150 left to pay.
What are you using how are you paying if you don't have a job?
I didn't have a job. I just, a week ago,
If you don't pay your bondsman, they're going to revoke your bond, and then you'll be stuck in jail.
I don't have to pay again until April 10th.
Mhm. All right, you got that, and you find a lawyer problem. So make sure you come back, and we'll see where you are on all of this. But most importantly, don't commit any more crimes while you're waiting on this one. Okay, get a reset in it. Thank you. Alicila Simeon.
All right, friends, let's go back across the hall again to Judge West, and this will probably be our final hearing of the day.
Just try not to look.
I know. No, when I gotta film stuff for social media, don't let me look at the camera myself.
Good morning. Are you Carlos Rodriguez?
Yes.
And just for the record, Mr. Salinas, you're going to be able to translate for Mr. Rodriguez today?
Yes, sir.
All right. And Mr. Rodriguez is charged in 24 DCCR 1584 and 1585 with indecency with a child by sexual contact. And what is the announcement?
Ready, Your Honor. I guess last time we were here, we had to deal with the inspection videos. So it looks like that was, I'll bet after your order was signed, both me and the state were able to get those videos and an investigative report.
Good.
There. So, and I believe state also filed motions for you to do an in-camera inspection of some CPS records regarding the children.
That's correct, Your Honor. There could be exculpatory information there, and so I do like to request
So I-
those records if
yeah.
necessary.
I signed that order just yesterday.
Okay. Yeah,
So that takes a little bit to get those records back.
understood.
And
I was unopposed anyway to that, so that's fine.
all right, so I guess what we need to do is reset it to get those records back. And then as soon as that happens, and typically what happens is they send 3 copies. They send an unredacted version to me, a redacted version to both of you. So you'll be able to go through it yourself. If there's something that you feel like has been redacted that I need to take a closer look to, or closer look at, then you can let me know. So we'll just do a normal reset. Not likely we'll have them by then, but
Understood.
if you can, just because this has been going on a little bit, and he's
Yes.
in custody, if you'll get with,
Gordon?
Miss Adams.
Miss Adams, I didn't want to say, I was about to say her first name, I couldn't, but yeah, if you'll get with Miss Adams and see if they can kind of move this one to the top of the list for us, since he's in custody and we're waiting on it now.
And Your Honor, speaking with the state earlier about, just as far as trial dates go, August was mentioned. Is that about as far as?
So what'll happen is, we have to get to that point to where it gets placed on the trial docket. I don't just put anything on the trial docket to kind of get more time. I want everybody to have all the discovery, and then for it to for sure be a rejection of any plea agreement. And so what'll happen is, once you are prepared to reject any offer, there's a document you'll do, plea bargain rejection, so that I have something in writing.
Yes.
As soon as that's done, it'll get placed on the trial docket. Our trial dockets are about 2.5 to 3 months
Okay.
turnover from the time that you get on it to the next
And
one.
I'll get a date with her.
But we'll need that rejection first and everything. And so I'm assuming you don't want to reject until you get the CPS records.
Yeah, and right now the current offer was from the last prosecutor. Ms. Pam here hasn't gotten a chance to fully review and give her own.
So I'll just do a normal reset, and then Ms. French can get an offer to you, and then we'll see where we get with regard to getting those records back. And as soon as that takes place, we can get it moved to the trial docket if that's what it's going to be.
Gotcha.
Okay.
Yes. Thank you.
Thank you. You can go back with the bailiff.
Okay, friends. Fairly heavy day. And an hour shorter than it normally is. But we're going to go ahead and call it for now. We will be back tomorrow morning, 9 a.m. Eastern, 6 a.m. Pacific, a half an hour earlier. If you're a channel member, do join us for the pre-show tomorrow. If you're not a channel member, fix that so you can join us, because I'm pretty sure Lindsay is going to give us her police blotter from Cadillac this time. At least that's what she said. So got that to look forward to. So go have yourselves a great Tuesday. I will see you tomorrow morning. In the meantime, take care. God bless.